Lord's board, matter relating my lord to ESI matter. My
ESI matter, fresh or
fresh, my lord.
to 2025?
My lord. My account has been freezed by the recovery officer.
When did you file the petition?
My lord, I filed the 15th April, my lord.
So why you are sleeping over it?
My lord.
After filing the petition, why you are sleeping over the petition?
What happened, my lord? My account
sir, you want listing, sir. What happened in the background of the writ petition? Since April 15th, why you are sleeping? List karantu 12 तारीख fresh matter.
May I be allowed to make a mention?
Yes.
The TRP of 2025 is supposed to be listed today. It has not come up.
There is some difficulty. Now it has piled up.
My Lordship, may kindly.
It is after notice or?
After notice.
After notice, there will be difficult. There is no time. We are exposed to a time constraint. You must understand. The days of working days and the working time, nature of cases.
Your Lordship, I'm for the wife. I'm just seeking a transfer proceeding. And stay.
It has no urgency. There are so many TRPC. You are not the only wife who has filed the TRPC. Once you are confident that you are the only wife who has approached the High Court, then you can definitely pray that I am the only person who has approached.
Your Lordship, kindly
you must understand there can't be any preference of simply somebody has filed, so he is awaiting. That's not the way to look at things. There are so many TRPCs today also. In which year matter?
25, Your Lordship.
25. Notice have been issued. Should we go after vacation? There's no point in, for your satisfaction, it can be listed, but that is a unrealistic picture actually.
No,
you must understand that this whole issue of long pendants and all that, it's not that simple. You give it. Give the memo, got a date for you. Yes.
Item 27 after notice matter. I pray after vacation, my lord.
There will be a change. Any adjournments will be allowed even after notice matters.
My lord. Item 27, my lord.
27, Mr. Suggested date, both of you.
Your lordship's convenient after vacation.
That I have been searching. I am not able to find in the. It starts with Monday, ends with Friday. Lordship's convenience. Now there is nothing.
19th June, your lordship.
You got it, sir. 19th June.
My lord.
Yes, Mr. Pradhan.
Yes.
19/6. Mr. Pradhan, 19/6 जान लेता? Yes. Yes, next.
Item 21.
Only speak to the microphone. Microphone on achi. Microphone on achi. Microphone recall.
Pardon to mention, item now 21.
Yes.
Kindly pray for adjournment.
Here the lady appears in person.
In person, I see on VC.
Yes, madam. The other side wants an adjournment.
Yes, sir.
Last time, I think you sought for adjournment to go through that petition.
Yes, sir. Sir, I prayed for time petition that whether I want to go for mediation or not.
Correct.
The advocate requested me for mediation.
What happened to your video? Balesore ki achandi? But amar problem achi. Acha. Well, carry on. There is some issue in the internet. Yes, please.
Sir, petitioner's advocate, they have requested me today that they want more time because of certain family issues of theirs. So, sir, I agree to it. If they want to take...
You also think about mediation. Look forward and don't be skeptical about everything, please. Whatever has happened, maybe you felt, agree for a date. Can you suggest a date, Mrs. Das? Can you suggest a date in June actually? Maybe 25th June or 2nd July or 9th July?
Sir, if a short date is given...
The short date actually comes in between the vacation. When actually it's not a vacation, but no old matters have to be taken up during the period from 19th June to 16th June. No old matters have to be taken up. They have to wait for that. Courts will be open, judges will be there, there will be adjudication, but only fresh matters and specifically urgent matters. So for adjournment, you have to think about starting with 17th June. That's the first 4 days of reopening. Then the next week is 23rd June. Then the 30th June. Obviously, you spill over to July.
June will be
Uh, 25th June or 18th June?
18 June.
18th June. On consent.
25th. My lord, 25th June.
Again?
25th June. 25th June will be better. 25th June.
ଗୋଟେ ସଜେଷ୍ଟ କରୁଛନ୍ତି ସବୁଥିରେ ଆପଣ ମାନେ ଗୋଟେ ଡେଟ୍ ରେ ବି ନା ବର୍ତ୍ତମାନ ତ ଭେନ୍ୟୁ ଅଫ୍ ଆସିଗଲା ଦିଟା ଟିଆରପିସି ଫାଇଲ ହେଇକି 2024 ରୁ ପଡିକି ରହିଲା
Sir, it will be
they
case.
are requesting for 25th. Only after would you like to have on 25th or 18th?
Sir, 25th is late, sir. 18th is.
18th. No, it's not. It's only 7 days.
Sir, बहुत दिन हेलानी sir. it will be case stay ହେଇକି ରହିଛି. ଆଉ sir, time
Thank you. I have been. I don't know whether you have been hearing me in YouTube or something. This I have been pointing out to all learned counsel that any matter filed whenever the notice is issued, at least the next step is that to file a TRPC or TRPCRL and get the matter stayed. Or even if not stayed, seek for adjournment. Obviously, with the court adjudicating regarding transfer, the court will not hear. The trial court will not hear. But it's available under law for transfer. So the whole process, the mandate of Hindu Marriage Act is frustrated. I quite agree with you. There can't be any two opinions. But it is better if you go for a mediation and a agreeable settlement. You are not compelled. Under law, you have all the right to prosecute your matter. But still then, if you go for mediation, you give up something, or you go for agreement to resume your matrimony, all those things are better options also. When looking at both of you, I think it is always an option. And this process of delaying the matter because there is a provision for transfer and it is available under law, you are absolutely right. ଆପଣଙ୍କର କ'ଣ ଆନ୍ସର ଏଠି ଯୋଉ ପେଣ୍ଡିଂ ରଖିଛନ୍ତି 2024 ରୁ
My lord, ଆଜି କରିଦେଇଥାନ୍ତୁ ବି ସାର୍ ଆଜି ପ୍ରେଜେଣ୍ଟ
ସେଇଟାର କ'ଣ ସେଇଟା କ'ଣ ତାର କାରଣ ଯେ ଆଜି ଆଡଜୁଡିକେସନ ହେଲାନି ବୋଲି ଆପଣଙ୍କୁ ପଚାରିଲେ 24 ରୁ କାହିଁକି ଆଜି ଯାଏ ରହିଛି you as a counsel you have to advise
listing
don't go by the exact formatting what the client is saying and client is happy to tell you
ଫାଷ୍ଟ ଲିଷ୍ଟିଂ ହେଲା ବେଳକୁ ରିଚ୍ କରୁନଥିଲା ମ୍ୟାଟର ଫାଷ୍ଟ ଦିଟା ତିନିଟା ଡେଟ୍ ରିଚ୍ କରୁନଥିଲା MS
pass on the buck to the court. Any TRPC matter they are taken upon priority. If you have mentioned it would have been taken up definitely.
Sir, ଆମ advocate जे ଥିଲେ ପଛ advocate ଗୌତମ ଚନ୍ଦ୍ର ରାଉତ sir, ସେ ବି ଆମକୁ ବହୁତ ହଇରାଣ କଲେ sir. ସେ ଗୋଟେ ଏମିତିକା statement.
ସେଇଟା ଆପଣଙ୍କର it's a matter of perception. ଆପଣଙ୍କର legal strategy ରେ you may not like certain things. Maybe you have a point against not against to tell so, but what I have found with my little experience of about more than 25 years that public perception or perception of a litigant varies from the lawyer. At times the lawyer's strategy is not appreciated by the so anyway now you are appearing in person, you can go for legal aid also, it's available, you can seek legal aid. ଲେଖନ୍ତୁ ଆପଣଙ୍କ ନାଁଟା ସାର୍
ସୁମିତ ଶତପଥୀ
Mr. Sumit Satpathy for the TRPCRL both TRPCRL both dita ଯାକ ଅଛି Sumit Satpathy for the petitioner, Jasmine Das in person लिखिए in person. The opposite party appears at the virtual court High Court of Orissa Balasore in person. The matter is mentioned by the learned counsel for the petitioner in presence of the opposite party in person. The opposite party in person, the wife expresses her concern regarding long pendency of the TRPC since 2024. In a brighter note, both the parties state about going for mediation. in a positive note. In a positive note, both the parties state about going for mediation. List on 18/6 on consent, list on 18/6/2025. Mark that 2 p.m. Liberty to mention before the assigned bench. You can seek legal aid, no difficulty.
Sir, pardon, sir. Actually, katha hoche, sir. Today I am fighting in person because, sir, without my consent, my previous ex-learned counsel, sir, he took steps to delete the names of other petitioners except husband. Sir, the fact is that they have tortured me a lot, sir, both physically and mentally. Sir, from the marriage got solemnized. Sir,
That is in the criminal case or which case?
Sir, I have filed a criminal case.
Their names have been deleted from the complaint.
No, sir. When I filed this TRP CRL case, sir, they filed TRP CRL case. I opposed it. Sir, this.
If it is about impleading certain persons in a particular petition, you file a petition. But basically, it becomes very difficult for are you a law graduate or practicing, even law graduate not practicing in court? It becomes very difficult to understand the nuances. So every procedure has some nuances. Implication of parties can be made by the court, but if you are saying in the present 2 proceedings where anybody has been deleted without you knowing, you can still file a petition. But I would advise you to seek legal aid and maybe legal advice. That way it would be better. It is not that difficult. I mean, don't be disappointed or that it is the end of the world because somebody has been deleted. You can file implication of parties stating all these things.
Sir, in the court of Justice Murari Sri Raman, sir, our ex-learned counsel, sir, se file karthile ki se amo without my consent, se ya kahile ki mu kade undertaking nochi that to delete the names of the other petitioners.
How do you know the exact court proceeding? Did you see it? Because now everything is recorded and available. Did you see that?
Sir, the order, but it was written, sir.
So there is a many ships between cups and lips. That's as the English proverb goes. So when the order is dictated, it is actually not exactly that. The conversation, because it is impossible. It's impossible. So the order of the honorable judge, as you are referring by the coordinate bench, there is no difficulty. You can seek modification of that order. Always.
It has been modified, sir. On the next date, on 16th April.
So that's it. What I've been telling you, that it has already happened. It can be modified. There is no difficulty. It's not that you have hit a roadblock kind of thing that there is no way ahead.
Sir, it has already been modified, sir.
Then what happened? They have appeared.
Sir, no, sir. Why I appeared in person was because, sir, I appeared in person on 16th April because, sir, my ex-learned counsel, he returned the file and he said that ki aau etira mu kichi kari paribini, apano jaha kariya pe chahunchନ୍ତି karantu. So, sir, seit pai mu in person.
That happens. Achha, one thing, write one line in the opening statement. Though the matter is marked to be taken up at 2 p.m. Since the 2 p.m. as the opposite party is appearing in person, it is taken up on mention at the beginning. Yes. So any order you are thinking that should be reconsidered by the court, you file a petition.
Sir, it has been modified, sir.
Correct. So let us see what is happening. Go for mediation, whatever can be done.
Interim order will continue.
Interim order did Karachi. Interim order dated dash passed by the coordinate bench shall continue till till 23/6/2025. Both matters. Sorry. Yes, please.
Sir, interim order will be continued again, sir.
Yes, because if the interim order is not continued, nothing remains to be adjudicated. interim order causing difficulty to either of the parties, and if the court here is to adjudicate, then what remains to be adjudicated? Either it is to be adjudicated here or the learned trial court who is taking up the matter. So there will be multiplicity of proceeding, which is not in the interest of because you also can be sure that the matter will go in your favor. So if unless the interim order is granted, you will also not get anything in of the entire proceeding. By the time because it is not that the court will wait for something, the learned trial court. So High Court, being the supervisory court, has to do something where the matter does not go on without being decided. So that is the difficulty. But yes, you are right. There can't be any two opinions that interim orders is causing a lot of difficulty in these kind of matters. Yes.
Your Lordship, item 32, Your Lordships.
Yes.
Yes, please. 32.
Yes, sir. This was the adjournment after the vacations, along with WPC 3
Pavitra Kumar Datta, you are
petition.
opposite party Dharmendra Sethi appear Kurchandi, along with 32 is assigned to whom? Mr. Swai, you can answer 32 is C6 adjournment. C6 adjournment. Am I audible? Again?
Yes, my lord, I am in DC, my lord. 32 it is assigned to me.
The city has given. Upon we change upon city. Rajdeep Pradhan SC. Date kondu?
18 June, Your Lordships. 18 June, Your Lordships.
Opposition so reopening week in 4 days. How many matters can be adjusted?
Your Lordships on 30 June.
30
June.
30th?
Yes.
Your
Your Lordships, along with the WPC number.
File memo.
Your Lordships,
not taking up your
it's
action.
already tagged with. Your Lordships,
Already
already segregated.
So that order is not modified.
Your Lordships, on 6th May, it is in together, Your Lordships. Today, I did not know how segregated.
ଆପଣ କଟାକଟି କରୁଛନ୍ତି କାଇଁ ଆପଣ ସେଟା ରେଜିଷ୍ଟ୍ରି କହିବେ ଯିଏ କାଟିଛନ୍ତି ତାଙ୍କୁ କହିବେ whenever there is no judicial order for detagging or delisting it may at times Mr. Datta there is a bona fide mistake, it is not intended. The listing process being computerized manual, you can be sure a simple wrong entry or simple mistake, somebody missed it to enter, then it goes out of the list, but there is no order as such, no difficulty. সেটা লেখি দিয়ে দিও কাগজে লেখি তাদের ট্যাগ করে পাঠাতে yes
please your lordship item 33 your lordship ADMLS 1 of 2025 your lordship
Yes.
this is maybe taken up today. There is a little urgency. We have filed an interim application for arrest of the tugboat.
when did you file the petition?
We filed it long back in March, your lordship. We had filed an IA.
Why-
and that
why-
time notice.
So how it can be become so urgent in May?
Lordship, what has happened is
once a suit is taken up, then other matters get impacted.
I understand, your lordship.
So you
So
wait
what
after
is-
vacation. There will be more space for the matter to be taken up.
So what has happened that
If you
Let me
are, sir, no urgent listing when the matter is yet to be opened by this court. There can't be any urgent listing. One thing I can try. If the matter is opened by this court, then I will list it. At least it will retain its position.
I will apprise your lordships of position. What has happened last week is, in spite of notices being issued and the opposite parties appearing, they have dispossessed me. I am the tenant of the vessel. So they have dispossessed me and handed over it to somebody else. That is why the urgency, and we have filed an IA to that effect regarding arrest of the vessel.
What is the suit for? Prayer for?
Prayer is for granting me the possession, your lordships. Continuing my lease agreement.
So whenever
And
somebody is
continuing
seeking
my
any
lease.
possession, somebody is seeking a possession, then it is presumed that he doesn't have possession.
We had
If
possession,
you
your
are
lordships.
seeking a
initially.
declaratory relief for possession, as you have stated so clearly, it is presumed, it has to be presumed that you do not have possession.
That is my prayer in the IA. My original prayer, if your lordship if your lordship is in the original suit, is continuing of the lease.
Original or a copy, that's it. No, I asked you the very specific question. What is the prayer in the suit?
pendent in the suit is not.
So
so
let us not waste
dispossessing.
time in mentioning. Let us not waste time in the mentioning.
Your Lordship, it is there before your Lordships at item 33. It was
If
there
it
on
reaches,
Tuesday.
it will be taken up. If it reaches, it will be taken up. But since a CP is there, Mr. Mahanti is appearing, it is being mentioned, it can't be taken up out of turn, giving priority over other matters. You see, you heard, you are present in the present VC today. Some a TRPC matters is saying that it is going on and it is for 1 year, it is stayed. On the face of it, you are unable to get interim order by filing a suit. And suddenly after 3 months, March, April, May, 2 months, you are saying that you require interim order. What prevented you? What prevented you from getting that interim order? So that
The position actually changed. During filing of the
must-
suit, we had possession of the vessel.
Then it is a subsequent action. If you say on affidavit that it's a subsequent action, the suit is also relevant. Was there any order in the suit?
There was no, only notice was issued.
So then
Your Lordship, may just
Yes.
hear it or keep it tomorrow and early because it is already there on
no
your Lordship's board.
prioritization, no prioritization of any matter. Matters are so urgent and every matter is urgent.
Lordship, as my senior is also mentioning, Lordship, the prayer in the suit was
The reason of you, both of you, not able to get an interim order after filing the suit in March,
Lordship.
and you are saying that you are appearing for who, Mr. Mahanti, for whom?
Plaintiff, he's my
The
senior.
plaintiff.
Plaintiff, you are saying that plaintiff files the suit and slips over the suit.
No,
In
Lordship,
the
we had not slipped over the suit.
So
Lordship. Lordship,
if you have not been able to get interim order, it is fait accompli. The
Lordship,
filing of any petition in court doesn't assure that you will get your order.
we are not on the ground. Lordship may just grant us an opportunity of hearing if we are able to
The
satisfy.
opportunity of will be granted not at the cost of others. No
Not at-
prioritization. If it reaches, it's fair enough. If it doesn't reach,
Lordship, all we are praying, if the matter does not reach today, may it be listed tomorrow.
not at all. Not at all. Then I have to list other matters. There can be any reason for a court to discriminate between petitioners and pick up a particular matter and take it up when the matter is yet to be opened. And more so, you see, it's not a fresh matter. I have to write that in order, that why I am picking up a particular matter which is pending since March. And interesting is that you are admitting in your plaint that you do not have possession.
No, Lordship. In the IA, we have stated that we have been dispossessed.
Then you are not listening to what Mr. Mahanti said. You
No,
can,
Lordship,
you can replay it. He
the
said,
No, Lordship, in the
now subsequently he has been dispossessed.
in the IA, it has been
And
stated that we have
the
been
declaratory
dispossessed.
relief is that or the mandatory relief is to grant possession. If you are seeking grant of possession
No, Your
by declaration of the suit by the court, then you admit that there is no possession.
No, Your Lordship.
There is a
Yes, you are mentioning something.
Your Lordship, it's a 20 matter. We are challenging the order passed by
No,
the.
I am not answering. What? Don't say what is the case number.
Your
What you
Lordship,
want
the
to please
urgency is
say.
that-
How can I know the case number?
Your Lordship, the urgency is that during the pendency of this case, the service benefit and the promotion has been withheld of the petitioner. So he's going to retire.
It's after notice matter or a fresh matter?
Lordship, it's after notice.
Which year?
2020, Your Lordship.
20.
20, Your Lordship.
So
Let it come for
no
final.
urgency. No urgency. It can be adjusted. It can be adjusted. There is no point in listing matters.
During
That you take a date after vacation if you want.
Your Lordship, let it come on Monday.
2020 matter. If something happens, that should not worry you because it is always the
He's
case.
going
It's
to
fine.
retire soon, Your Lordship.
Sorry, I am unable to hear you because you are not speaking to the
Your
matter.
Lordship, the petitioner is going to retire soon, so the matter will
So
be.
whatever it may be, you do not know the date of retirement. If you know the date of retirement, you should have mentioned it. And in any service matter, any order passed during pendency of a case is going to not impact the petitioner. That is the settled position of law. Whatever benefit accruable to you, you can get it with interest even. So that can't be. So picking up your matter and taking it up, I have to record that order.
Lordship,
There must be some semblance of logic of going out of turn and targeting matters. You must understand that. The court has a task cut out. There can't be any targeting of matters by a particular court, by a particular bench.
It's assigned to the court number 17, 20 matters. We are up to 19
He doesn't know that.
service matters.
ଆପଣ ଆର କୋର୍ଟରେ ଦେଖନ୍ତୁ ଏଇଟା now thanks to him otherwise it would have been wasted by judicial order. Suppose I direct for listing here you look at the just kindly ଦେଇଛନ୍ତି list assignment ଦେଖିକି କରନ୍ତୁ
Service matter 19 there.
ନହେଲେ ତାଙ୍କ ପାଖରେ list ଦେଖି ଦିଅନ୍ତୁ service matter up to 17 here
19 there.
19.
up to 19.
I oblige your lordship.
So kindly file it in the registry or the go before the other court.
Oblige your lordship.
Supplemental list, item 1.
Lordship,
Kindly speak to the microphone. Yes.
yes, my lord, there is vacancy. My lordship,
Sorry,
there is vacancy, my lord, available.
that was the question.
Also, the last order, my lordship, directed to take instruction with
See, order
regard to
actually ମିଳୁନି ମୋତେ କାଇଁ. All the scanning ହେଇନି ମୋତେ. Written instruction ପାଇଥିଲା ଦେଇ ଦିଅନ୍ତୁ. ଠିକ ଅଛି ମୋର ମନେ ଅଛି.
ଆଜ୍ଞା.
ହଁ ଦିଅନ୍ତୁ ମୋତେ. Any written instruction you give it to me.
and that's through mail. It is come.
ହଁ ଦିଅନ୍ତୁ mail ରେ print କରି ଦିଅନ୍ତୁ. ଆପଣ ଯଦି ଚାହୁଁଛନ୍ତି help my staff will help you to get the printout of the mail. You can access your email and take a print. କିଏ ଏଠି ଅଛନ୍ତି ମତେ actually ଦେଖାଯାଉନି ଏଠି ଯୋଉ ଥୋଇ ଦେଇଛନ୍ତି ଗୋଟେ ଏଇଟା କାହିଁ ଥୋଉଛନ୍ତି ମଝିରେ ଆଜ୍ଞା what this desktop monitor will do here appear କରୁଛି ମୋ ଆଗରେ ଆଚ୍ଛା you have taken a print you are having a print Mr. Naik of the email
Yes, my lord.
ମୋ କଥା କିଛି ଶୁଭୁନି ଆଜ୍ଞା yes
Yes,
I thought that you want a printout. No, he was holding, I could guess it, but I wanted to confirm. Say, order pade gale. तब upload करना है. Yes, अपन upload करना है. अपलोड ही नहीं. हिमांशु 24/4/25 मिस्टर नायक
Yes, my lord.
এটা আপলোড ହେଇଛି
ହଁ
অর্ডার আপলোড ହେଇଛି তাহলে আপলোড করছেন
upload ଟିକେ ଡେରି ହେଇଥିଲା ହେଇଥିଲା.
ଫ୍ରି ନାହିଁ
That's with me, my lord. WhatsApp.
ସରି
That's with me.
uploaded ତ କହୁଛନ୍ତି ଏବେ
Yes, that is
Upload is that's upload.
because I could not find so I'm asking that why
Yes.
is the order. Yes, then yes, you have obtained instruction. There is
There is vacancy, my lord. There is vacancy. Yes, my lord.
so any other submissions?
No, my lord.
That's what. But that factual aspect has to be
Yes, my lord.
taken note of. So SK Tripathi for the petitioner. Mr. D. Mahanti, AGA for OP number 1. K. Naik, opposite party number 2. Mr. Aravinda Mahanti, advocate for AX Bhubaneswar. The judgment formatted for the Para 1 to Para 1 to 8. Repeat. By order dated 24/4/2025, the following was directed. Mr. Naik, thanks to you that, I mean, you have to be given the credit that a person who is visually impaired, lost one eyesight, 60% or 40% in other side, he could achieve something after roaming around in so many hospitals, so many places.
That the appellate board.
That creates a trust in the system.
And that the appellate
And we
board.
started today rather in a disappointing note. A young girl of maybe in her 20s, she's so disappointed with the system. She says, You can,
That
you can
appellate
seek
board
a-
has given such
I understand,
certificate.
But suppose now is
There is
again
no
you
fault
have-
on the
again
part
you-
of the authority,
you
my
have-
lord. And there
So
is
that
no
is
fault
how-
on the
that
part
is
of the
how
authority.
But I mean, at least that should give you satisfaction.
Yes.
I mean, end of the
Yes,
day,
yes,
you
yes.
feel that you have
Yes.
done something.
Yes.
So that's it.
Yes.
Correctly. Now, of course, Mr. Tripathi and Mr. Mohanty's role is also very important, because the AIMS did the correct thing by already examined, his eyesight was already examined, and they produced the report. And thanks to the order of the coordinate bench, when the matter reached me, by that time everything is settled actually. Yes. Only following was directed. Para 9 ta quote karibe. The learned counsel, Mr. Nayak, appearing for the opinion number 2, has obtained instruction. Copy sir दे देले अपन पार कॉपी अछि गोटे कॉपी दे दियंतु मिस्टर महांती को, एटलिस्ट मिस्टर त्रिपाठी को दे दियंतु आ गोटे करी दे देबे
WhatsApp रे दे दउछ।
हां व्हाट्सएप अपन कोटा को पैराग्राफ ता कहउछन सिलेक्शन थी बोली। अच्छा,
Last
Para
in not cell, my lord.
as on date, there are 5 ST vacancies available in the cadre of junior assistant due to non-availability of qualified candidates during selection process.
Last paragraph, last line, my lord, number 3, that the 3 vacancy. My lordship, there is only mention the vacancy.
ये को कैटेगरी में?
SC category, but in the coordinate bench, an order is there. In they're saying that once the reservation is physical, and there is no necessity to subcategorized.
That the Supreme Court judgment.
For this reason, and
So-
the advantage has not been quashed in that bench. For this reason, there is vacancy, and the benefit can be taken by the petitioner. Only mention, my lordship, there is vacancy.
Do I have to refer to that earlier order?
Yes.
Because after that judgment in this persons with differential ability,
Yes, my lord.
it is said that it is itself a category.
Yes, my lord.
You don't have to give
That
horizontal
cannot be
reservation. It's a
determined.
vertical reservation.
Yes, my lord. That's the judgment.
And by email, electronic mail, dated 6/5/2025. From the opposite party number 2. The copy of the email is taken on record. This is 5850.
Yes, my lord. If required, my lordship judgment.
The letter, the email indicates the following. In not sent to Neki, ST vacancies per job. Quote করবে পারা এটাকে রিসিভ করিবে ইমেল ইজ টেকেন অন রেকর্ড করছেন টেকেন অন রেকর্ড in view of the clear vacancy available, the petitioner belonging to the PWD category, he shall get the benefit of getting appointment against the vacancy as would be given by the authority. The writ petition is allowed and disposed of with the aforesaid order. This court puts on record its appreciation of the learned counsel appearing for the parties in assisting the court to arrive at a rather arrive at a conclusion in a petition pending for last 7 years. More so, considering the plight of the petitioner. Wait.
Item 2.
Maharana, have you appeared for TPCODL?
Yes.
Kebe appear kala?
Let's.
Mr. You are Mr. Mahapatra.
My lords.
A or V?
V. Mahapatra.
Mr. V. Vaibhaswat Mahapatra.
Vivaswat Mahapatra.
Vaibhaswat Mahapatra. V. Mahapatra for the petitioner. Mr. L.K. Maharana for the opposite party. वकालत तब केबे फाइल कल?
Let's that I'll take instruction recorder nahi hai. I think.
Can I record or you will verify?
I'll verify.
So Maharana Learned Counsel appearing for the opposite party submits that he shall verify if wakalatnama on behalf of the newly added na kaun thile?
No, they were original.
Wakalatnama on behalf of the opposite party has been filed. So, in case the wakalatnama has not been filed, the same shall be filed within 5 working days.
5 working.
Within 5 working days. Is there interim relief achi? Mahapatra?
No interim relief.
No interim relief. So list after vacation?
Yes.
On consent list on date karan?
207.
207. Yes, Mr. Mahapatra?
My lords.
Yes. 207 is actually in the smaller calendar in the bottom.
Item 3.
I remember.
Mahanti,
I have to file the further affidavit. Let it come 16th. Why not? Can it be?
So why you are not? That bench is available. I am really surprised.
16th को मुझे next week को रखना चाहूँगा.
Mr. Suraj Mahanti for the petitioner. Mr. Sanjeev Swai AGA.
16th.
Sanjeev Swai AGA for OP number 1, 2 and 3. As paid for list on
16th, your lordship.
list on 16/5/2025. The difficulty would be that before vacation, unless you get that same APL listed, then the whole thing gets. It will spill over to the after vacation, and now you are saying that the urgency.
Whatever your lordship, that is correct. But in CMPL, he has no power to.
Sir, that you don't have to. I have some. Sir, BK Naik,
Yes,
for the petitioner.
No, this is regarding the appointment of a controller dealer. We are the consumers. We want that our this PDS.
The PIL prayer is not maintainable. I don't have the roster. The determination is not with me.
PDS commodity roster.
PDS commodity, the prayer is in the nature of PIL. If you want a particular person to be appointed as a control dealer, you have to move. Either it is a statutory provision where you have a right, which provision permits that the consumer will appoint the control dealer.
Control dealer,
Fair price of dealer will be appointed as per choice of the consumer.
No, choice of the consumer.
Then why? I don't understand this. Kindly mark your writ petition. 1 to 5 are villagers.
Villagers,
consumers. They have no stake in the whole process. It's a specific statute which has a mechanism. It's not like excise policy or excise duty that excise act that public grievance or public opinion is sought for.
Billets, in this matter, I am appearing for OP number 5 billets.
Sir, please wait. Let the case be admitted. So Naik.
Yes, Milord.
This is your look at your prayer and the petitioners are the villagers.
Prayer.
Or you prepare and refer to a statutory provision where you have any right.
Right means, we will be affected because of the appointment of the self-approved by the
For
dealer.
that, does the statute, this PDS control order, Essential Commodities Act, provide anything?
So say that is the authority will decide regarding appointment, but
So Nag, it can't be in the air.
Madam?
Well, it cannot be in the air that the court will not refer to anything and will pass a order. The read court exercising 226. Suppose you are saying either it can be a PIL, no difficulty, but PIL obviously I cannot take up. It's a division bench matter, not an assignment.
Man, sir, refer the matter.
How can I refer? You have to decide what you want to do.
Madam,
So that is why I'm asking if there is any statutory violation or any authority is to act upon anything, those things can be done, but not a PIL prayer.
ନାଇଁ ସେ ଏଥିରେ ସାରା ହଉଛି ରୁଲ 4 ରେ କହୁଛେ ସେ ପ୍ରିଫରେନ୍ସ ଦିଆହବା କଥା ଗ୍ରାମ ପଞ୍ଚାୟତକୁ ରିଗାର୍ଡିଂ
This is
ସିଲେକ୍ସନ
not the forum to have this personal agenda. Personal agenda, read court cannot be party to a personal agenda.
personal no.
Sir, if somebody not getting preference, if he has a right, he has to fight for his right. He doesn't come up. Villagers come up regarding giving to somebody. And the opposite party number 5 is seeking a relief.
Yes.
How in a writ petition the opposite party will get a relief?
No. Actually, this is the appeal provision as also, Lord.
That is besides the issue, sir. The Sarpanch of the Gram Panchayat wants to have this PDS distribution in his hands. How he will get a relief here?
Well, actually, the appeal provision is there. Section rule 19.
Maybe, sir. You want to prefer appeal?
Appeal.
Don't want to press the writ petition?
Liberty may be granted.
Liberty is always there. Suppose I do not grant liberty or pass a order that you cannot file appeal. Will it be appropriate? Can it be sustained? It cannot be. You file a memo. If at all you do not want to press the writ petition, you have to file the memo.
Liberty may be granted too.
No, you always have the liberty. The liberty cannot be curtailed by a court.
Any one line observation. Any observation me. I will not press anything more.
To be like observation.
Any observation of I will not. Rule 9.
The writ petition has been filed by villagers of so and so gramo panchayat ka jahan. The following prayer. Therefore, it is humbly prayed that not be quashed. Along with a prayer, dispose of their representations dated representations annexed to the writ petition marked as Annex 13 and 14. With a further prayer to appoint the Gram Panchayat to distribute the public distribution system commodities. Public distribution system लिख ले bracket रे PTS. On being asked the learned counsel for the petitioner submit that there is no specific provision for the villagers to be interested in a particular villagers to be interested in distribution of PTS commodity through a particular agency. He further submits that the villagers shall approach the authority, if any, available under law for redressal of their grievances. Mr. Pradhan, RC Pradhan, RK or RC?
RC.
So RC Pradhan, Learned Counsel, submits that
For
he
the
appears
opposite
for
party.
the opposite party number 5, files Wakalatnama. Wakalatnama shall be taken on record, scanned copy be updated. Wakalatnama receive kar diyo. Upin number 5, Sarpanch of the Gram Panchayat. It is submitted by the Learned Counsel for the petitioners, villagers, that the Sarpanch, the Gram Panchayat should be appointed, and Likhichin Agribold. Gram Panchayat should be appointed for distribution of PDS commodity. The submission to record. Para. Memo of date filed by the petitioners through their Learned Counsel is taken on record. The petition stands disposed of. Yes.
All.
ଆପଣ ଏଇଟା ଦସ୍ତଖତରେ ଏଇଟା ପଢିବ।
Communicated.
The notes more দরকার নেই. Please, I only simply request you to look at
Prayer portion.
para 3 of the order dated. ଅଛି order ଟା ଆପଣଙ୍କ ପାଖରେ?
ହଁ.
Para 3 of the order dated 22/4/2025.
That I
Kindly read that.
after
demise of the petitioner.
The Learned Counsel, who is also her husband, has substituted himself and has started appearing in person. The petitioner in person is requested to go through the aforesaid orders, particularly the orders number 3, 13, and 37, and prepare a note indicating the prayer that is surviving the writ petition to be adjudicated. He also requested to circulate the note to the Learned
He
Counsel.
shall also produce the relevant rules as directed
Yes,
earlier.
that I have complied.
He also requested to calculate the note, so that note, which part of the prayer now survives.
Mine. That I have prepared, filed the memo and encouraging the.
So how can it be? How can the prayer run into 7 pages or 3 pages?
No, that I have submitted the notes I have prepared. That is
Sir,
note on surviving prayer. I have listed it, and I also.
So which prayer? Kindly turn to the prayer paragraph. Kindly turn to the prayer paragraph. Prayer paragraph is para page 11 of your petition.
Yes, madam.
Please,
The
just look at the prayer paragraph.
The petitioner most respectfully prays that your lordship may be graciously pleased to direct the opposite bank to release the dues forthwith as submitted in foregoing para number 16.
16. Kindly stop there. Kindly stop there so that we can refer to para 16. Now, kindly find para 16 at page 8. It reads, the petitioner submits that the authorities have released. Did you find para 16? Just few pages, one page back. Turn around the page. Just the last paragraph in page 8. That is para 16. You are referring to that to be your prayer. The bank should pay you. Just kindly read that.
Yes. Page 8. That
16.
The petitioner submits that.
The
Kindly
petitioner
read it.
that the authorities have released only for own contribution to provident fund and gratuity without intimating the details of principal and interest components. The other dues such as pension or bank's contribution, leave encashment for the accumulated leave period at Singapore from October 2004 till September 2007, reimbursement of payment of income tax 1426.50 Singapore dollar, interest on 9372.30 Singapore dollar deposited on 7th-9/2007 till 25th-1/2014 as applicable in foreign currency as fixed deposit to staff encashable, payable in Indian currency at appropriate exchange rate. The petitioner submits that.
So this para 16 is a money claim.
Correct?
Now, the difficulty is that did you approach the authority for claiming para 16?
Yes.
Or straight away you have come to the High Court raising for the first time para 16?
I have already filed one earlier to this petition that is bearing number 20403/15.
That the question is different. I am not asking any number. I am asking a much simpler question.
That is
Para 16 is not contained in prayer. Prayer refers to para 16 in the petition.
Yes.
Para 16 is a money claim from the bank, your employer.
Yes. Which I have received.
So para 16 is, have you approached your employer to give you para 16, whatever is narrated, or you have straight away come to the writ court asking for para 16?
No.
That's the question.
I have submitted representation and then there are no response. Then the petitioner filed.
Which page? If you have
13. Yes, 13 kindly see.
So para 16 corresponds to?
Para 13, annexure 10. This is the copy of the order of the Hon'Ble High Court. So far.
No, sir, not High Court. At times I don't know how I am.
Yes, I have
not been able to.
I have submitted a representation to the bank.
Which page, sir? Representation asking for the whatever you have stated in para 16. Which page of the petition or which annex are marked?
That I have referred to earlier petition, which were disposed.
How the court will look at the other petition?
This is the order.
When para 16 is there in the petition.
Yes.
And you say that because para 16 kindly mark, you are not referring to any annexure.
No, this is the.
Kindly look at the petition. Don't say no before starting a sentence.
This petition, I have submitted the orders of the.
Am I clear to you?
Yes, I have submitted representation. They have referred.
So you do not refer to that in para 16. Look at para 16. It doesn't refer to any annexure. In your petition, para page 8, page 9, it doesn't refer to any annexure.
No, that is there. I have not referred.
So then how the court will know?
No, because I have already.
You see, the court is here not, you see, it's a summary proceeding.
Yes.
Writ petition is a summary proceeding. At least the pleading and annexure should be there. That is the semblance of pleadings. I mean, CPC you can apply. Entire CPC is definitely not there.
No, only because I have submitted the representation to bank bank did not consider. I approached the Honorable High Court.
Mr. Ponda, I think you have heard it. Mr. S.N. Ponda, Learned Counsel, submits that anyway, so para 16, you have a annexure, but you have not filed it.
No. But because
yes, Mr. Misra, any idea that what Mr. Ponda is saying?
No idea, because earlier representation, the earlier what he is referring to actually is interest, he doesn't say about all these things. Para 16, he said that earlier representation was rejected, we are challenging the rejection.
Para 16 also doesn't refer to any representation. Earlier or maybe part of the earlier order.
Your Lordship's question is correct that he has not approached the earlier the bank on this issue. The first time he is making the allegation, making this argument. So that is the reason why all these things.
My lord, I am sorry to say that already we have made a representation. Bank did not respond.
Sir, I am extremely sorry that you do not enclose the representation to the writ petition. The court has to repeatedly ask you.
Yeah, because
is it not a sorry state of affairs and you are saying it is
because of the order? Kindly see page 40.
Kindly look at because is it a mistake for the court to look at the prayer and the pleadings?
That is my
With your experience, the judge will not look at the court. Let us not take the judge. The court will not look at the prayer and the pleadings and adjudicate. And it is a writ petition where it is summary in nature only.
The prayers are there.
It is a writ of mandamus.
Writ of mandamus.
And prayer is there.
I am.
And your order has been.
The court cannot amalgamate that or amend the pleadings, taking into consideration all your writ petitions. It is not possible.
My lord, so I am sorry to inform you. In earlier court,
sir, I am not. Sir, please don't. Mr. Ponda, we have to spend our time purposefully. The simple question is that para 16, you do not refer to any annexure. The first question is that whether you moved the authority, you say yes, I have moved the authority. Yes. Then the next question is that where you have moved. You say you refer, though you do not give the details, you say that there is a representation made to the authority.
And order is also there. High Court's order is.
So High Court's order is there. So that cause of action no more survives. Is it your submission? Para 16, you are not pressing anymore.
No, I am pressing because.
So if you refer to any pleadings in your paragraph and prayer, either you substantiate with a representation, or at least you can give their details so that they can respond. I can ask them that what happened to this.
No, that because I have submitted the representation and High Court has already directed to dispose of this matter, terminal benefits. So I cannot find it.
This cannot continue. We have already spent sufficient time and reasonable enough time also.
And moreover, my lord,
से जो नोट टा मते दियंतु जोटा करिसंती
दे जे कोर्ट रे फाइल करछि सांकु
फाइल करंतु फाइल कले हबनी फाइल कले सेटा तो who granted you liberty to file that? If you look at the order, I never asked or did I observe that it should be filed in the court?
No, I have submitted the counter.
आपण कॉपी टा दियंतु काउंटर नु आपनकर ऑर्डर जोटा 22/4 ऑर्डर रे. Mr. Ponda, one better suggestion is that you engage a lawyer actually. There is some difficulty in your part because maybe it is your personal case. You are unable to comprehend the pleadings, basic pleadings, facts. You are unable to comprehend. So, if you compare this note on surviving prayer for adjudication,
my lord.
आपण कॉपीडा भी मते दे दिछन
हां सर मु कोर्ट रे फाइल
एते एते कोन दरकार
कोर्ट रे फाइल कर
आपण केबे फाइल करछन
मु 5 तारिख फाइल करछे 6 तारिख ता सारू कॉपी देछि Let it come.
It is new. This is flag 70. So surviving prayer, just compare your surviving prayer with the writ petition prayer.
Writ petition prayer.
Ah.
And also along with the
Mr. Ponda, kindly let us not jump around. Let us complete the process. In the writ petition, what is your prayer and what you have mentioned in your memo? Just kindly look at it.
prayer at page 11,
Right, sir.
the petitioner most respectfully prays that
No, you don't have to. You have to compare that.
Yes,
When you ଆପଣଙ୍କ note ଟା ଟିକେ ଧରନ୍ତୁ. Note ଯୋଉଟା ଆପଣ ଦେଇଛନ୍ତି ମତେ ଏବେ ଦେଇଥିଲେ. The note you have furnished in the court, just hold it and compare with that prayer made in the writ petition. So whether it matches or it is something else. Yeah, I'll seek assistance of Mr. Udgata. Mr. Udgata, you spent some time on this.
Yes.
So, part 16, I have progressed nowhere. As far as para 16 is concerned, what Mr. Ponda is saying, I am unable to follow. I requested the senior Mr. Misra. He is also unable to understand what he is saying. Let us leave there. But now he has filed at least a note.
whatever prayer.
Kindly, I am addressing Mr. Udgata,
Yes.
I mean, the assisting counsel of the senior counsel. So now the rest of the prayers, he has prepared a note. So out of the writ petition prayers in para 11 and page 11 and 12, just compare it and say that whether anything is left out. If they are additional things, so there is no point in going into those things. Or you can obtain instruction. But I mean, precise to only confine to that those 5, 6, whatever he has written. First thing you have to please compare with prayer already made in the writ petition lying before this court. And there is already a order number 33, 37, all those orders by the court, because because those orders are also binding on me. Subsequent court cannot change those orders and appearance lekhon to Mr. S.N. Ponda for the petitioner. This item.
Aye.
S.N. Ponda for the petitioner, Mr. Manoj Misra, senior counsel, along with Mr. B.N. Udgata for the opposite party. Referring to the order dated 22/4/2025. Referring to the order dated 22/4/2025, it is submitted by Mr. Ponda. Appearing person, the counsel no. Mr. Ponda, S.N. Ponda in person. Counsel liquid. Submits that in terms of the observations made at paragraph 3 of the said order, he has filed a note along with a memo. Copy of the note has been served on the learned counsel, Mr. Udgata. Also available on record, marked as flag 70. The Mr. Stop. Mr. Ponda was requested to refer to his prayer regarding release of dues as submitted in para number 16 of the writ petition. Para 16 is quoted herein. On being asked, Mr. Ponda submits that he has not annexed any document as to whether document to the writ petition as to whether any representation application was made to the opposite party bank for release of any dues as mentioned in para 16. Stop. Then para writ petition para 16 also does not disclose that whether the petitioner approached the opposite party bank for receiving any dues as claimed therein. The learned counsel, sorry, Mr. Ponda, learned counsel, Mr. Ponda submits that. Are you sure that this is subject matter of another writ petition?
Yes.
Submits that.
I have submitted in that writ petition, Annexure 1, page 13 and page 14.
Submits that the claims of the petitioner, claims of the deceased wife of the petitioner appearing in person. As mentioned in paragraph 16 of the writ petition, are subject matters of WPC number
20403 minutes of 15.
20403
of 15.
2015, disposed of on
17/11/15.
17/11/15. Then Sapara, it is not understood how the claim of the deceased employee can be again re-adjudicated in the present petition. The learned counsel for the opposite party is again requested to go through the note submitted by the petitioner, legal heir of the deceased employee, appearing in person, regarding surviving prayer. Note along with memo dated कर देवे 5/5/25. It is further observed, it is further directed that out of the 6 prayers mentioned in the 6 prayers, no, 6 claims mentioned in the said memo dated 5/5/25, whether they match with the prayer made in the writ petition, any claim, those have been already adjudicated or yet to be adjudicated by the bank. Adjudicated havani considered. आपण कौन consider करिवे ना adjudicated को दे देवे कौन करिवे?
Consider.
Don't be more confused than the judge. At least I seek your assistance. ଆପଣ କେତେଟା ସେ ଯୋଉ କହୁଛନ୍ତି କେତେଟା କିଛି ହେଇଛି କି? Because I am unable to comprehend the facts actually. What has happened and what was the demand, what was paid, what was not paid.
ଯାହା ଦେଇଛି ମୁଁ କହିଛି ଯେଟା ନଦୀ ଆଇସ ଲିଷ୍ଟ ହେଇଛି
ସେଇଟା ତ ଆପଣ ସେଥିପାଇଁ earlier benches କହିଲେ ଆପଣ staff rule ଆଣନ୍ତୁ କୋଉ rule ଆପଣଙ୍କୁ entertain କରୁଛି ସେ ସେଇଠି ରହିଲା
affidavit କରି ଦେଇଛି
affidavit ଦେଲେ ହବନି sir ସେଇଟା ଆପଣ ଯଦି ସେ ଏଇ rule ରେ ସେ then it is a matter of adjudication.
ସେଇ sir.
Mr. Ponda, whenever you straight away come to the court without any consideration by the appropriate authority, this will happen because court doesn't have the wherewithal to adjudicate also.
No, I have submitted.
There can be a adjudication on each of your claims.
No, I have.
And it can be subject matter of a litigation. Of course, definitely. But there is no litigation, there is no adjudication, nothing. You are not yourself sure when you demanded this paragraph 16, by which document. Your colleague, Mr. Udgada, he doesn't know.
The only thing is because I have submitted this representation.
After vacation, kebe aspect kebe? Date kebe apne ko na? 9/7
जून
जून रे
18 19 14 ଆପଣଙ୍କର
no
July 1st week
ठीक है no if we are clear in a direction, the court is sure, you are the petitioner is sure, then I think the opposite party will not stand in the way. We are really struggling to identify what is the amount regarding what. ଆପଣଙ୍କର ଯଦି internal ombudsman ହେରିକା ଥିବେ like service sector ରେ ombudsman ଅଛନ୍ତି,
Service sector nothing.
so they are much better equipped to understand this
Service
thing.
sector ombudsman.
ଆପଣ ଯୋଉ currency କହୁଛନ୍ତି conversion ହବ ମାନେ something will be given to you, Singapore ରେ ଥିଲେ ଏତି ମିଳିବ, all these things how the court will understand.
That is,
And you are simply writing as a gospel, I mean kind of a scripture.
no,
So
my lord.
Singapore dollars 5,213.
Yes.
So what is the basis? Where from it has come?
No, I have given.
Anyway, today at least July 1st week.
ମୁଁ quantify କରିଦେବି ଆମ.
2/7.
My lord, I will
Sir,
quantify the amount.
quantification is I can better quantify than you.
That
I
is-
can convert Singapore dollars to Indian rupee. That's not the problem. The issue is that how do you know this amount? Where from you have got the amount?
That is the repetition.
Yes. But
Repetition
petition
and also counter affidavit.
then para 16 I asked you that whether you have approached the authority.
No.
What is the decision
My lord.
pending on that?
My lord, counter affidavit, they have also
Sir, let
submitted.
us not beat around the bush. We are simply beating around the bush. One like list on 3/7. 2/7. Yes, Mr. Pandit, 2/7.
Man.
There are only 8 working days in the reopening week. Then it goes to July.
Item 6.
My lords, item 6, my lords. Last two occasions, your lordship have been gracious enough to allow us to file an objection to the.
You have been more gracious. You have been more gracious in taking
That's
time.
actually we have taken two times to file objection to the interim application for condonation of delay. As admittedly, there is delay of 457 days. We have written letters.
So you are convinced that maybe for some 400 more days in filing objection. When the delay is 400 days, the objection will take 400 days.
Well, it has
That's
been.
there is some logic. Some logic definitely. Mr. A. Acharya on behalf of the Mr. M.K. Mahapatra for the petition appellant.
Lord, I am Suman Sahoo, my lord.
I'm so sorry. Today Acharya has become Sahoo. Sumit Sahoo.
Suman Sahoo.
Suman Sahoo. Mr. S. Sahoo on behalf of M.K. Mahapatra. For the appellant, Mr. Prabhu Prasanna Behra. For the respondent, the learned counsel for the respondent seeks further accommodation to obtain instruction and file objection to the IA. IA 27 or 24 for a heading. Upon the subheading order details. On consent list on page 6.
My lords, well fine.
7.
Oh, bless.
Your name, sir, Nityananda Behuria. Mr. N. Behuria for the petitioner. Opposite party blank. As per the office note put up by the registry, the requisites for issuance of notice with by registered oblique speed post with AD was filed late on 19/2/2024 instead of 13/2/2024. The learned counsel for the petitioner submits that the delay was due to inadvertence and may be condoned, and notice be issued as directed by the order dated 8/2/24.
Again.
Order 8/2/24. Prayer is allowed. Let registry shall proceed to issue notice fixing early returnable date. Issue notice by RP with AD. Fixing early returnable date. List after SR. Liberty to mention or listing.
Stay up further proceeding.
Aguru achi ki order?
Yes, aguru nothila.
Again?
Aguru nothila.
But default of the appellant will result in stay
Not
against the respondent.
Not defaulting.
There is no such provision in CPC.
I am extremely sorry, my
It
lord.
doesn't appeal to common sense. Doesn't appeal to common sense. Let them appear. If you are still now successful, let us see. This looks odd, Mr. Beuria. That since the appellant has defaulted to file the requisites, then let there be stay of the proceeding.
Now,
I have already recorded your submission.
No, pardon to mention before your lordship that once a notice had issued to the opposite party and that was returned
I have
back
seen
because
that. You should guess that when I asked you the order, you said 8th of February. Then you should have informed that I have seen the order. So you don't have to repeat that it was earlier sent and all these things.
second time notice. Deliberately
Second time or fourth time, it is not, that's not important. So that is default of the appellant. How can you ask for a stay of further proceeding when it is not?
No, initially.
Suppose it is initially granted, then you can seek extension. That's the only possible prayer.
Because the long court below is proceeding the matter, posted the matter to 19.6 for evidence. Therefore, I want to.
It is up to you. File adjournment there by showing this order. It's for you. But I cannot direct that since you have failed to file the requisites, let the proceeding be stayed. That would amount to this. It looks very odd. Yes.
One adjournment maybe.
Again?
Adjournment if for that maybe.
No. That you do, but I have not observed that. I have not observed that. I have granted liberty to mention that much I can do for you.
That liberty.
Yes. Liberty is granted. If any adverse order is there or any imminent order which will affect you, you can mention for listing. The IA, on the day the notices were issued, IA was considered. It has to be, even if it is not mentioned in the order, once the coordinate bench has not passed the order, I cannot. Yes, next.
Item I.
Your Lordship, my senior Mr. S.K. Das, due to some personal difficulty, could not come to court today. So your Lordship may kindly.
For the petitioner after vacation. For the appellant.
As your Lordship.
Delay has not been condoned.
No, your Lordship, there is an intricate question of law involved. For that reason, your Lordship.
It is submitted by the opposite party, Mr. Rajdeep Pradhan. He submitted that in absence of senior counsel, Mr. S.K. Das, the matter may be adjourned. List after vacation,
as per your Lordship's convenience.
There is no date as per my convenience. It starts with Monday, ends in Friday. No date is. You have to be. It has to be between Monday to Friday or dates.
After vacation.
Which date?
Appeal may be filed.
Sorry?
Copy upon appeal may be served upon.
The learned ASC appearing for the respondent number 1 submits that he may be provided with copy of the appeal memo and other IAs. But there is no defect here, so this is LA Appeal 46 with Banerjee.
Yes, your
Lordship. Banerjee, yes.
Yes, your Lordship, against rejection of enhancement petition that was filed by the petitioners.
So after notices were issued, how many opposite parties are there? So this is only one.
There's only one, your Lordship.
So what happened to the notice? It is long back. Mr. Pradhan, you will appear for the special LAO.
My lord.
Special LAO. Balangir Khordha New Broadcast Line. You will appear?
No, my lord. Sorry. My lord.
On the last occasion.
I shall be appearing.
On the last occasion, my Lordship, Mr. Prabhu Behra was appearing.
Special law, government will.
Prabhu is omnipresent, he can appear, but Rajdeep is not omnipresent. Prabhu, by as such, is omnipresent. There is an order date number 4 dated 24/12/2021, long back. issuing
Yes, Your
notice in limitation.
No, Your Lordship, that was with respect to condonation of, not condonation, exemption of payment of court fees. And that was, this case was actually taken as a reference.
Kindly look at the order. When I am reading something, you must be confident. Unless I am reading something else. When I am referring to order number 4 dated 24/12/2021, you can use the paperless, that all-in-one system. Look at the order so that you will be clear. प्रधान देखो से order. This is Devabrata Das's order. So that order is passed in a connected LA 54.
Yes, Your Lordship, that
So
was with
54 is not.
that, Your Lordship, that order was passed with respect to the applications pertaining to the exempt
54.
payment of court fees.
No, 54 clearly is on limitation actually. The
But that order,
the learned judge has also said the reasons that for expeditious disposal. So how they are connected? I mean,
no, that was only taken into
anyway,
consideration as a
you just
reference.
have to verify all these things. Because if yet the delay is to be condoned, it cannot be taken up. Court fee is one aspect. Court fee, maybe the court can temporarily exempt you from depositing the court fee. But beyond that, it has to delay has to be condoned. Whether there is any delay, the entire order sheet of 54 is enclosed here with maybe the same proceeding. Some other person,
proceeding.
maybe adjourning land, somebody has.
Yes, Your Lordship. It was
Suppose,
similar proceedings.
do you have that 54 file?
We don't have
Here it is also not there. Only copy. The learned counsel for the appellants will provide extra copy of the LA appeal as well as other IAs and connected the annexers to the learned AC. Date केबे कहले? कहले आपण केबे कहले?
10
List on 10/7. 10/7/2025. On consent list on 10/7/2025. The learned counsel are requested to verify whether delay has been condoned by any earlier order and court fee and any other regarding payment of court fee by the coordinate bench. As similar orders have been passed and kept on record, passed in LAA 54 of 2019. Yes.
Item 9.
Yes. The brief action. So regarding rest of the matters, learned counsel waiting for the rest of the matters. I think
We'll finish before lunch.
okay.
Definitely.
So if it spills over, maybe you can seek adjournment. Yes. ଗୁଡା ତ ଭାବି ଯାଉଛି କଣ?
Let's have a glance at that.
6-5.
Yes, well, just one, Lord, spelling, not maybe required correction. Just one word. The Lordship should see.
6-5 to upload it.
Upload in Ethera Suni.
Again?
Ethera Suni, but online it is there.
Yes, 6-5.
Yes, your Lordship may come to just the last line before para 6.
Take out. Refreshing. Order to scan.
Just one word.
You are referring to paragraph. No, I have the. In fact, I have got the order sheet separated. This is Valkyrie.
So just last line before the para 6 starts, which would be, I think, internal page 10.
Internal page 10. Yes.
Not instead of like 2 lines prior to para 6, prayer may therein be reserved instead of resolved.
Oh, reserved. Yes.
That is all.
Correct.
So we had sought for reserving our right to reply on that, right to make submissions on that.
The learned senior counsel appearing for the plaintiff refers to the order dated 6/5/2025 to point that at internal page 10, last 3 lines of paragraph 5, last 3 lines of the paragraph 5, there is a apocryphal error. In the said paragraph 5, that will error. In the last but third line, reserved is to be read as reserved. Top para. The word reserved is to be corrected in the said order as reserved. As per the rules, corrected as per rules.
Just to finalize or summing up, and with a small reply to what has been stated by my learned from the last occasion, is giving the issues that we have, my lord, so far as our side is concerned, for consideration before your lordships.
Yes.
So there are 6 issues that we have, my lord, noted down. First is, my lord, whether non-payment of court fee within the time specified by the court followed by an application seeking modification of such order renders the suit liable for rejection under Order 7, Rule 11.
Yes.
So to that extent, my lord, we have relied on Umrao Devi. Then, my lord, second issue is whether there can be an automatic dismissal of the suit without passing a decree as required under Order 7, Rule 12 of CPC. Third is, my lord, can the plaintiff file an application for amendment under Order 6, Rule 17 after such specified date fixed for the payment of court fee and aim to reduce the quantum of court fee? To that extent, we have given 2 judgments, that is again the Umrao Devi and the Pradeep Kumar. Whether the application under Order 6, Rule 17 to be considered prior to a decision is rendered on Order 7, Rule 11. Again, we rely on Pradeep Kumar, then the Dr. Mumtaz Ali, that Madhya Pradesh High Court judgment, and the judgments which have been cited in that. Then, my lords, whether non-payment of court fee creates any legal right in favor of the defendant for the purpose of consideration of rejection of amendment application under Order 6, Rule 17. So, to that extent, my lord, one judgment is there. The 1961 SCC Online SC 280 that I will, my lord, place before your lordship.
1961 SCC Online.
1961 SCC Online Supreme Court 280.
280.
I'll give a copy, my lord.
Yes,
That
yes.
only, because other I have already, my lord, exhaustively dealt with, so I need not go to that. I'll straight away come to this. Then whether the application or Order 6, Rule 17 filed by the plaintiff changes the nature and character of the suit. So these are the 6 issues as far as we are concerned, or the
The
points of consideration.
The sixth one also, you cited some decisions.
Yes, my lords.
You have
That
cited
JC Ocean Liner versus Golden Progress,
Golden Progress.
and that Altus Uber, that same offshore Redry versus Altus Uber. The single bench judgment, which has been approved subsequently by the division bench.
Yes.
So far as this point number 5 is concerned, the judgment, I'll just, my lord, prior to that, I'll just start with what they have stated on the last occasion. The judgments which have been cited by my learned friend.
Because this will continue this.
Thank God. The lordship should see the first two decisions that have been relied upon by them, that is that Radha Goyal and the Jatinder Pal Singh. Just a second.
Yes, Radha Goyal.
That is 2024 SSC Online Daily 2318. They have given in their compilation.
Radha Goyal, you are
They have referred.
You the neutral citation?
No, they have referred.
Okay.
They have given the compilation. I'm just giving a lot very brief reply to those. Just one line.
Yes.
Not even I'm going to, my lord, through the judgments. That is for your lordships to consider whether it has any applicability so far as the present issue is concerned. The first two judgments, which is regarding amendment, cannot be permitted to evade court fee. Both the judgments were post-trial judgments, where the trials have already begun. So I had
that point you have articulated. Actually.
Yes. So that is why I said, my lord, I will not get into that judgment. Simply, I will distinguish it saying that those are post-trial judgments. Then, my lords, another judgment which they relied upon was, which was read out in detail at 6. That is Dr. Jubir Ali Abindin and others versus M.A. Niazi, which is 2000. That is serial number 6 of their compilation.
Yes.
Again, that is regarding deferment of court fee till the culmination of the proceeding or the suit. At the stage of decree, if it is required then to be paid. So it was for the deferment, nothing else. So to that extent, my lord, the others also I have relied upon those the judgment of Nawab Jan and all that.
No,
so I did not.
No, they are still I mean, it little bit digression. They still hope that you will say that I will pay the court fee and let it be deferred. So perhaps that is so that they are waiting.
That is also already in the prayer. In the prayer, they have stated that defer it till the, if at all it's payable, defer it till the arbitration is done.
No, deferring as for because
regarding the amendment,
referring to Jubair Ali. Jubair Ali actually.
I am talking about the plaint and the amendment there.
Correct. Jubair Ali actually confined. I mean, the suit was pending in Delhi. It's not regarding arbitration.
No.
But so that is how I said it's a digression. I want they want that. Yes.
So, my lord, now coming back to the issue regarding whether I can seek a security in a different High Court under Admiralty Act, which they pointed out, and seek a security, whether it will be an interlocutory order or whether it can be a substantive order. And the straight answer is in Section 5 of the Admiralty Act itself. If your lordships can have a look at it.
Yes, please.
Yes. If your lordships would just see 5.1, the High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is the subject matter of an admiralty proceeding. It doesn't say the suit which is pending before the High Court. The wording used here is an admiralty proceeding. Definitely, my lord, while the framers of the act, they could envisage that there can be a situation where there might be multiplicity of proceeding because of the subject matter of the suit being at different places. So that is why it says that of an admiralty proceeding, it says the High Court may order arrest of any vessel which is within its jurisdiction for the purpose of providing security against a maritime claim, which is the subject matter, not the admiralty suit. It says an admiralty suit. So admiralty suit can be at any High Court, but again for the purpose of securing it, I can file a second admiralty suit. Because the jurisdiction of the subject matter of the original admiralty suit or one of the admiralty suit is situated in another High Court. That is the peculiarity of the act and the enactment itself. So that is why, my lord, from the very beginning, when I raised the regarding amendment, I tried to impress upon your lordships that my claim is before the Gujarat High Court. Leave apart the arbitration also. Gujarat High Court, and in Gujarat High Court, I have valued it with all the 9 vessels and paid the ad valorem court fee there. So that is covering the cost of the vessels which are here. Because had those 5 vessels which are within the jurisdiction of Gujarat High Court would have covered the entire valuation, I may not have had the reason for seeking arrest here. The subject matter I could have filed again, but not the arrest. So that is why I said the valuation, since there it was 400 odd crores, we calculated the total, out of which 153 crores we have valued so far as these 2 vessels are concerned. So that is why we filed the subsequent admiralty suit. It is not that it is to satisfy the decree of the suit. It is to satisfy the claim in the suit. But the difference is here is the claim, because under Admiralty Act, it is the claim which is to be secured. So the answer to my learned friends raising that issue is in the statute itself. That section 5 permits me. Because he said a suit only for the purpose of arrest. A suit simpliciter cannot be filed. But here is a case where there are 2 suits. One is before the Gujarat High Court. One is before this Honorable Court. And here the suit is regarding securing the price or securing the proceeds or at all the valuation of the claim before the Gujarat High Court. So it is not in satisfaction of a decree, not an interlocutory application, neither is a suit simpliciter for the purpose of seeking arrest of the same. Because my prayer is, as I read out earlier also in my plaint, was for a declaration to say that these 2 ships form part and parcel of the settlement agreement. Because that declaration will create that right for the seizure, for the satisfaction of the securing the claim, and the prerequisites of a maritime claim. Because this security also which I am seeking before your lordships is covered under section 4 of the Admiralty Act, which says any dispute regarding sale of a vessel, sale or purchase of a vessel. So my endeavor before your lordships was that it is not that what they say is as an interlocutory application. Neither it's a suit simpliciter for us. Then, my lord, the next thing is, and the judgment which was shown by my learned friend, that African Eagle case, that was of 2014, prior to the coming into effect of the 2017 Act. And while Altus Uber referred to it, it clarified subsequently that the issue has to go beyond this, what has been decided in this Lord African Eagle case.
African Eagle is 2007.
2014. African Eagle. And Altus Uber is 2018, post the coming into effect of the Admiralty Act 2017. So, while African Eagle being decided, it could not have foreseen a situation when what would happen after the new act comes into play or has been enacted.
No, has the new act impacted what is decided in African Eagle?
Yes. That has been also, that is why, my lord, they read out those paragraph 35, 36 before your lordships. After that, the reading which I read out on the last occasion, that covers that, my lord, the issue regarding the impact of it. So para 37 in fact refers to African Eagle. After that, it has been set out that why these changes are required.
37 in Altus Uber.
In Altus Uber. Because para 37 onwards, the Altus Uber case has gone ahead for laying down the procedure or what it should be. I need not go through the entire judgment again. I'm sorry. So I did not read out last occasion, I have read it out. The lordships can only note down the 37 onwards.
African Eagle is prior to 2017 amendment.
2000, yes, 2014.
14 amendment.
Yes, ma'am. Because the full bench of Golden Progress, my lord, as I read out before lordships on the earlier occasion, stated that what is required to be done, but it didn't lay down in certain modus operandi or the modus.
Just a second. Just a second.
Yes. Of the law and how it should be developed, the commercial law, and keeping in view the Admiralty suits and everything. So, yes. In Golden Progress, it says that inconsistent with law be devised with help of advancing the cause of justice in accord with Article 7 of Arrest Convention 99. I read out before lordships in exhaustive terms also those paragraphs. So, in fact, Altus Uber is the first case after the new act came, where it to some extent devised the modus.
You are referring to paragraph 37 in Altus Uber.
Altus Uber. 37 onwards.
Yes.
And my lord, that is on the basis of 77 of that golden progress, where it says the law should be devised and in what way. And alter super concretized it by the single judge, upheld by the division bench. Then the next, my lord, what they submitted was regarding Order 7, Rule 11A. The cause of action, how it will change.
No,
Or
because
no.
because you have been emphasizing on actually Order 7 Rule 11A, though perhaps 11C is to be seen, but somehow the plaintiff has been emphasizing on 11A, so they had to answer 11A.
The 11A,
I mean, like
the cause of action. My lord,
I mean, they have to answer that. That way you can say it.
All right, my lord.
Yes.
Because my saying is the cause of action is existent. The reason being the peculiarity of the enactment of the statute itself. Otherwise, my cause of action in Odisha would not have been there.
Yes.
Then, my lord, regarding the defendants not being a party in Gujarat suit, that also they raise. My lord, there is no dispute here, at least before this honorable court. I'll come to the Gujarat, that it's an action in rain. The vessels have been made parties and their owners. They don't dispute that they are not the owners. They don't dispute the involvement of the vessels insofar as the settlement agreement is concerned. So whether I have made them a party before the Gujarat High Court or not, that can possibly a defense for them for misjoinder, non-joinder or whatever may be before the Gujarat High Court.
Yes.
But before this honorable court, when I am relying on the same settlement and the suit which I have filed there against the vessels in rain, because only after notice, if they appear, once the owner appears, then it converts to person name, as I read out in the earlier judgments. So that to that extent also my suit is safe. And then so far as the court fee or the valuation, as on the last occasion at the almost the fag end of his arguments, my learned friend stated that if at all the consequential relief is that 153 crores or 100, whatever may be the valuation of those two vessels, then that should be at least the relevant court fee. But again, my lord, coming to that, that can only be referred to the registry if at all the amendment is allowed. So if they presuppose that the amendment is to be allowed, then this is their prayer that it should have been this, not the 20 lakhs which I have made the valuation. And my respectable submission in regard to that is, when I have paid the court fee before the Gujarat High Court for the entire claim amount, then do I need to pay it again? Number one. Number two, my lords, how I value my other injunctive or declaratory prayers. They said 20 lakhs has been plugged out or whatever. The Court Fee Act permits the plaintiff in a case where the relief is injunctive or a declaratory to value it himself. He need not give any reason for that. As we day in, day out see in normal suits, that the prayer for injunction is valued at 1,000 rupees, the suit is at 50,000 rupees. That is only because for the purpose of jurisdiction, creating a jurisdiction in the court. The pecuniary jurisdiction will decide before which court it has to be moved. So to that extent also, my valuation, it may look very rational to naked eye or to a normal person, but that is the prerogative of the plaintiff. And if he has valued it, can the defendant say that it is absurd? Unless they say that the consequential relief has to be valued then. So that is why they said that since the consequential and the judgment they tried to bring before lordship, that the consequential relief should be the basis for the claim or basis for the court fee calculation. Okay, that I had shown on the last one, 7.4, but section 7.
Section 7?
Of the Court Fee Act.
Court Fee Act.
That's 2 minutes. 7 IV. Note C and D.
Yes.
So it says it is the prerogative of
7 IV,
C and D, where the prayer, my lord. Very confused.
It treats where the land pays no such revenue.
No, my lords. Where the injunctive relief, my lord, I'll just, because this book is a little confusing, my lord, I'll just.
For declaratory decree, consequential relief, then.
Yes, my lords. That is section 7.
Yes.
IV. Then
right.
DE. I'm sorry, my lord. C and D.
IV. Roman 4 starts in suits.
In suits.
In suits. Then
for movable property.
Yes. Then headings.
To property B is enforce the right.
Yes.
To share in joint family. C is for a declaratory decree and consequential relief.
Right.
Then D is to obtain an injunction.
Oh, yes.
Then for accounts, F. According to the amount at which the relief is sought is valued in the plaint or memorandum of appeal. In all such suit, plaintiff shall state the amount at which he values the relief sought.
For injunction, to obtain an injunction. For accounts, you are referring
C, D and F.
C, D and F. Yes.
So it is for the plaintiff. And the last, my lord, what they said that they have accrued a legal right and they showed the judgment. To that extent, my lord, just one judgment I would like to show to you, lordship. The judge, bench judgment of the Hon'Ble Apex Court. That is, Lord, AIR 1961, page 1299, which is also HCC online, my lord, as we have mentioned in the notes. May I take your lordships to para 2 on the second page. The principles. May I just place it. Para 2 on the second page at the bottom. The Court Fee Act was enacted to collect revenue for the benefit of the state and not to arm a contesting party with a weapon of defense to obstruct the trial of an action. By recognizing that the defendant was entitled to contest the valuation of properties in dispute as if it were a matter in issue between him and the plaintiff, and by entertaining petitions preferred by the defendant to the High Court in exercise of its revisional jurisdiction against the order adjudging the court fee payable of the plaintiff, all progress in the suit for the trial of the dispute and the merits have effectively frustrated for so and so, my lord. That was in that particular context of the case. Then, my lord, after 4 lines, how by an order relating to the adequacy of the court fee paid by the plaintiff the defendant may feel aggrieved, it is difficult to appreciate. Then, my lord, again the jurisdiction of the revisional so and so. Then, my lord, para 3. Para
Yes.
3. But this section only enables the defendant to raise a contention as to the proper court fee payable on the claim and to assist the court in arriving at a just decision on that question. So it doesn't create a legal right which will be defeated to attract Order 7, Rule 11. Yes, as I said also on the earlier occasion, they can raise it. It is for the court to decide. But no right of theirs, much less any legal right otherwise, is taken away if the amendment is allowed or the court fee issue is not decided by the court. So on this context, I again, my lord, on the next page.
We'll continue after the recess.
Just 5 minutes if you're lord.
Okay.
Just 5 minutes, not
Yes,
even.
yes.
Just the last, the next page, my lord. I'll just, my lord, it's just the last 2 minutes. The anxiety of the legislature after 5 lines, 6th line.
The anxiety of the legislature to collect court fee
Yes.
from the litigant.
Due from the litigant is manifest from the detailed provision made in Chapter 3 of the Act, but those provisions do not arm the defendant with a weapon of technicality to obstruct the progress of the suit by approaching the High Court in revision against an order determining the court fee payable. In our view, High Court grievously aided in entertaining so-and-so on the question of court fee at the instance of the defendant when no question of jurisdiction was involved. And this apart, my lord, so that is why, my lord, I go back to the principles laid down in the LIC case. And also the other, my lord, Dinesh Goyal case following the LIC case. Finish. So,
Then you refer to
Dinesh Goyal, my lord. Then again, then Supreme Court, same line in the line of the judgment of the LIC. The identical, my lord, points. So your lordships can consider a light C on itself. So that's all from our side.
Lord, sorry to trouble your lordships. And both of them are not there.
No, actually, they have, as I told, I have assignment. So I have some assignment now. I'm just, yesterday I was told, in between this, maybe around 1:30 or 1:45.
Okay.
So I have
may I just take 2 minutes only so that your lordship close the case, because already your lordship have heard in extension.
No, we can resume at 2 or maybe.
No, because they are not there. Otherwise, your lordship may close it also. But they are not there now because they are not there.
I mean, Mr. Nanda may not be there, Mr. Pati.
Yes.
If he's there, if he's there, and I can assure Mr. Nanda that I will not take away any argument what is done. I will only say on the basis of records what would be my submission to your lordship. 5 minutes I'll take after.
Mr. Mukherjee, you are saying?
I am also not there.
No,
I had informed your lordship yesterday.
Yes,
both of them are not there. Yes. But what 5 minutes? Nothing.
No, we can start at SAR 2. Suppose
no. Yeah,
no difficulty. We can start at 2, maybe 5 minutes past 2.
Grateful.
All three of them satisfied.
I am satisfied, my lord. I won't stand.
If you have heard Mr. Padi, he says that he wants to make the submission in your
Absolutely.
I can tell your lordships that I will not make a submission which will require a reply by him. So it will only on records.
Since you said that, we can continue because
we have concluded. I have given a small notes also.
Yes.
That. So for your lordship.
Yes.
Deeply obliged, my lord. It's a pleasure, my lord.
And as far as my arguments are concerned, everything has been recorded by your lordship. So we don't need to give any.
All right.
Yes.
No note prayas.
No, in fact,
again. Our only anxiety is
এটা দেখিও পড়ে উঠে जो ग्राफ
we are submitting the pen drive also, that soft
Yes.
copy
of the list of dates
Yes.
in the company.
What you can do that at times there are too many pen drives. So in a piece of paper you attach that
We've already put the-
because everything digital has its limitations also.
No, it's already there. The name is already there.
Yes, yes. We'll continue for maybe for a few minutes after this.
Yes.
Yes.
Then I may be excused.
Yes.
Yes.
Go on. Yes, though I said the promise to be at 2, but again that assignment as I told you.
But we always know that how your lordships are for a whole day getting busy and different issues, including administrative matters. So in fact, it's so difficult job.
Oh, I mean, you have been very closely observing. You have the privilege of closely observing. So,
Maybe pardon me, Lord.
kindly speak to the microphone. The microphones are active. Yes.
I may be pardoned before my learned senior addresses your lordship on issue of.
Still not audible.
Am I audible, my Lord?
Yes, yes.
Before my learned senior addresses on the issue of Order 1 Rule 10 intervention application.
Not addressing it. Not addressing it.
And
Not addressing.
I'll just make a prayer, my Lord. Let my learned senior me confine his argument to his intervention application only.
Lord,
For any other submission, we have strong objection.
You have an objection, your lordship. May I accept that objection, then not also record. My lord, let me tell your lordship what. First, your lordship may hear me, then thereafter.
What is your sir?
Lord, so far as the amendment
Still there is some.
Is still now. The case of the plaintiff. The case of the plaintiff.
Just a second.
Yes.
Just give me a minute.
Kindly turn to page 10. Page 10.
Ownership ଆପଣଙ୍କ ଇଏ ଦୃଷ୍ଟିରେ ownership ଦରକାର ନାହିଁ। What are you referring to?
So, I mean the plate.
Page?
Page 10. The case of the plaintiff before the lordships at the time of passing of this arrest order. The case of the plaintiff. Para 12. Para 12, my lord. Page 10, para 12. Have you also got page 10, para 12 of the plate?
Yes, please. The plaintiff has quantified.
Yes. The plaintiff, it's a loss. What the loss they say. The plaintiff has quantified its losses. What is their quantification? Is a loss. As the differences between the current market price of the 9 vessels, that means vessels here, vessels Gujarat, vessel there, and the intended distress sale price at which the plaintiff would have purchased the vessel from Samson Underwater. Samson Underwater, the defendants. The purchase price under the settlement agreement of the vessel was fixed at INR 170 crores. the market value of the 9 vessel debt is 598 crores. That means what he says, what he had agreed to sell in a distressed sale is 170, was the price agreed was 170 crores. What is the market price is 598 crores, 3 times of
the distress price.
This is a factor which your losses has to keep in consideration, and that differences between this 598 crores and 170 crores is 429 crores claim. The 429 crores claim is the market price according to their estimation, which is 3 times of the price which the plaintiff had agreed. And the price, that's a factor which your losses cannot omit from your losses mind, that this is preposterous. Lord, be that as it may, my lord, that when they filed this suit, my lord, on this 429 crores, deliberately or inadvertently, they did not mention about Gujarat suit. I'll tell you that most likely it is deliberate, not inadvertent. Though, of course, they would know, as the plaintiff knows why he has not said.
Yes.
Because in the Gujarat suit itself, they have made the self-same claim of 429 crores. If this fact would have been revealed in the plain, possibly, these are all hypothetical, then the court would have possibly come to a conclusion that you have already a suit of 429 crores. How what suit you are having a 429 crores here? So they had missed out. Why? On the basis of facts only stated. I am not going beyond it. That whether this fact of not mentioning Gujarat suit was a deliberate or inadvertent mistake, but my submission would be a deliberate. But what was also there, I am not going to the merits of the agreement or the validity of the agreement. They filed an application before this court, 2 applications, 6 and 7. 7 was for court fees, 6 was for arrest. The 7 was for, yes, in the court fees application, they said, I am liable for a court fees of 85 lakhs. This is also important, my lord, because actually the liability found out by the court is 12 crores. I am liable for a liability for 85 lakhs for court fees. I'll do some case management by getting it transferred back to Supreme Court, and hence I am paying 75,000 rupees. Be that as it may, the court allowed them and granted 6 weeks' time to pay the court fees, not pay 80 lakhs, pay the court fees, or 4 weeks' time, 4 weeks' time to pay the court fees. While granting this time, Lord, the court passed an order of arrest. In the arrest order, your lordship says, in the arrest order, they kindly see, my lord, is order dated to 19/3/2025. 19/3/2025 of your lordship's this court's order. And this is the order number 1. First is court fees granting time. The second is, my lord, MOUs, approvals, agreement. Then the lordship says 9 vessels. Then they say at para 10, the present suit is filed seeking an order on decree for a sum of 429 crores. So it is not, that means the suit arrest order was based on the claim made by them is 429 crores. The arrest order was only on that facts. So that makes the arrest order, my lord, in the change scenario, what will happen, that's for the lordship to consider. But why they filed this? They filed, the respondent, defendants appeared, and I also appeared as an intervention. I'll tell you lordship now, my role. They are before that. But I am a person for whom I had made also an agreement later to with the defendant. Not only made an agreement, I advanced 180 crores, and by 80 crores, the property which was admittedly to the mortgage to the IndusInd Bank and the Saraswat Bank earlier was released and mortgaged to me. The mortgage order is there. It was mortgaged to me. And hence, I was a necessary party concerned with the suit under Rule 17 provides that if anybody concerned with the suit will be allowed to be heard by your lordships as an intervener. I am not a defendant. There is no claim against me. I am not concerned about the suit of claim against them. I am only concerned because my mortgage property is under a dispute. I filed an application 9. But
Your application is numbered as
9.
Number
9.
9. Yes.
9. 9 was filed and it was mortgage. And in the application I was given that the property is now mortgaged to me. In their agreement, it is accepted that there was a bank lender. But what happened is they had an agreement with the defendant. Agreement. In the agreement was an inchoate agreement saying that in future, it will be released, lenders are there. Lenders means the IndusInd Bank and the other bank, Saraswat Bank. Then we'll agree on a price. And on the price agreed, it will be done. If you don't do it, we will have to give me the loss. And the maximum cap was made 170 crores. That's the agreement they have. In the agreement, they said, in future, you have to sell it to me in a cap price of 170. In fact, the agreement was not 170 crores. They said that the maximum capping is 170 crores. You have to sell me, otherwise the loss suffered me. What is the loss suffered by them? Would be loss suffered with the value of the price or the value of the purchase they would have sold, which is there in different forums. They are claiming it could be not 303 times, but that's there. That the claims, if at all it will be sustainable, because their case before defendant claim, in an application for vacation of stay, that this is an inchoate, indeterminate agreement, incapable of implementation, and hence they ask for vacation of stay. But here, your lordship, pause for a moment. If a person, your lordships are directed for an Admiralty suit, a suit to be arrested. If anybody comes forward straight to your lordships and said that kindly release my ship, your lordship will put him to terms. That if you take the release, give the terms. Here they did not ask for release of the ship. They asked for the ex parte ad interim order to be vacated. While this Admiralty ex parte ad interim order was being considered by your lordships and the arguments were advanced by the defendant because they had applied for vacation and the advance was replied by the former counsel who were appearing. The closing date of 17th, the last date of court fees came. 16th, the last date came. So the question would arise that if you are not paid the court fees, how will the suit survive? On 17th, they filed this amendment saying, A, give me the amendment and now value the suit at 20 lakhs, make it within 75,000. And what is the claim they are now asking for? That this is an aid of Gujarat suit. Now, without two tests stated by LIC, my hand note. Yes. Your lordship sees in the last paragraph 7110. The prayer for amendment is 71.4.3 is malafide. There somewhere. Here. Lord, your lordship have seen 71.4.3.
Yes.
The prayer for amendment is malafide. For understanding the prayer for malafide, your lordships have to see that what is the original plaint? What is the time asked for court fees? What is the application made for court fees? These are all application made for court fees was that I'm not liable, I'm liable for 85 lakhs, I'll go for case management. Then after the date you file an amendment, number one. Number two, that whether the entire process becomes nullified. And in fact, my lord, as on today, the IA6 survives in your lordship's court as a claim of 429 crores, that IA for arrest. That's not amended. IA6 is not amended. Then now it is a claim of 20 lakhs and hence its continuance of arrest. It's same, remains the same, 429 crores, which was claimed and which was granted. But obviously, court under conception that 429 crores is a large sum. I'm not also now addressing your lordships that whether this giving of the court fees it should not be arbitrary, it should have certain nexus, and whether it is not rightly being. I'm not addressing that. I'm only addressing that. Kindly say 71.10, where the amendment changes the nature of the suit or the cause of action. Now, nature of the suit, what was the nature of the suit? Claim of 429 crores. 71.0. Where the amendment changes the nature of the suit. What was the nature of the suit? Claim simpliciter for 429 crores. Now the prayer is that this may be arrested, kept for the aid of the Gujarat suit. Or the cause of action. The cause of action changes. The amendment changes the cause of action. So as to put up an entirely new case. This is an entirely new case, my lord. Foreign to the case set up in the plaint. My lord, it is foreign to the case set up in the plaint. My lord, what in the amendments are normally allowed? Supposing you make something wrong, you supplement or cut out something, which will still the suit survives in the same manner as it was, but doesn't change anything, nature and character. But it is absolutely, my lordship, if foreign to the case set out plain, the amendment must be disallowed. That lordship may see whether however the amendment sought is only with respect to the relief in the plaint. Relief in the plaint here means, my lord, supposing a person has asked for 100 crores and somebody says, no, I don't want 100 crores, I want 20 crores. I want 10 crores. Relief is reduced. It's possible. It is not that the relief totally changes and is predicated on facts you already pleaded. Lord, is it predicated on the facts already pleaded? Facts not pleaded. Gujarat is not pleaded. It is not predicated on the facts pleaded. In the plaint, ordinarily the amendment is required to be allowed. Right? Lord, my humble submission to lordships that keeping that in mind, I'm 180 crores and it's mortgaged to me. Now, if it is mortgaged to me and the mortgage has come in between and I have advanced 180 crores and you are allowing a suit and getting it arrested. So I am a substantially affected party. I'm not saying that as a proposed intervener, I'm making this submission because your lordship can ask me what has happened to the intervention application because of paucity of time. As such, your lordship is having graces and have to give so much of time. Time is not enough. If 8 is hard, 9 is hard, 10 is hard, all this is done, and the same problem with us, the arrest continues. Arrest continues and continues. So 9 was kept in the bench because if 8 happens, but like I am telling your lordship that your lordship need to go to 9 now. If application for amendment is required, then 9 also not required. When 8 would have been allowed, vacated, then also 9 would not have been required. So for that reason, 9 was kept apart. So a fact remains 180 crores I have given. It's on record and then in the main, and it is hypothecated to me. So I will 100% submit to your lordships, as I assured your lordships that I will not take more than 10 minutes only that under the circumstances, my humble submission to lordships, that lordship may only decide on the question of amendment first. I mean, while deciding the other things, if your amendment, your lordship is allowed by chance, then other things would arise. Whether this, on the basis of an amended plaint, whether the arrest will survive, whether the amendment plaint, the court fees has been rightly paid or not. Hence, amendment and rejection are simultaneous. If the amendment is not there, then rejection has to happen. If the amendment is there, only the rejection will not happen. So hence, my lord, I had assured 10 minutes and I'm not taking more than 10 minutes and I'm told nothing beyond what's on record. Nothing. I'm not submitted a whatever is on record to your lordships, and only because the entire issue is, my lord, I mean, it's an adversarial litigation side. Defendants would always like to have more and more and more adjournment because they have the arrest order in their favor. But the plaintiffs. But our anxiety is well known to your lordship that the arrest order is there. So your lordship may see, and I'm rule 17, and I said, let him, and that's all I'm saying.
Permission of your lordship, my lord. Am I audible?
Yes, yes.
My landlord senior has addressed everything except the issue of his locus standi to address your lordship on the question of amendment. He has addressed everything. One thing I will draw your lordship's attention to. Your lordship may kindly have a glance to order 6 rule 17.
One thing you should be satisfied.
My lord.
Mr. Nanda has addressed this thing.
My lord.
Because
it has been extensively heard by your lordship.
There is a tacit understanding that if unless the amendment is allowed, that is a tacit understanding. But since the lawyer will not take a chance, I mean the litigating party will not take a chance. Exactly. So obviously 11 is allowed, argued. 11C is also argued.
The sequence will be decided by your lordship.
So maybe, but whatever has been argued by Mr. Padhi, senior counsel, has been answered. That you have tried that it is not mala fide and it is doesn't change nature or character.
Why I am saying, my lord, whether my client of my landlord senior has a right to audience on the question of amendment. He may address your lordship on the question of, my lord, intervention, order 1 rule 10, I understand, my lord. Your lordship may kindly have a glance to order 6 rule 17, my lord. Your lordship has dealt with it, but I will just take 2 minutes of your lordship's time, my lord.
No, it's fine. Once we have decided to continue, I mean, the hearing is continuing. No difficulty there.
Deeply obliged. Your lordship got it?
Order 1, rule 10.
No, order 1. Order 6, rule 17. Amendment.
Order 6, rule 17, amendment.
My lord. Your lordship got it?
Yes.
The court may, at any stage of the proceedings, allow either party to alter. Your lordship may kindly mark the language, my lord. Either party to alter or amend his pleading in such manner and on such terms as may be just, and all such amendments shall be made as may be necessary for the purpose of determining the real question in controversy between the parties, my lord.
Yes.
So it is the parties involved in the suit, they can address your lordship on the question of amendment. Second thing, my lord, just to whether the client of my learned senior can address without there being a pleading, my lord. There is no objection to this effect in the amendment application. He could not have filed his objection before being made parties. Can you be?
Sorry, could not get you?
We filed an amendment application, my lord.
That's right.
We served the copy on the parties.
Saying that the intending intervener,
my lord,
has not filed any reply to your amendment.
Without pleading, my lord, can they address your lordship? So all the issues raised by you, my learned senior, may not be addressed or recorded by your lordship. That is what I, except the question of his right to be pleaded. This much, my lord.
Yes. Back on to somebody. I'll just record the submissions of Senior Mr. Nanda and Mr. Padhi. Yes. And also hear his response.
Yes, he also submitted. Here, submissions.
Then take your seat. No. I'll just again ask you the IA that was been addressed by Mr. Nanda, just to confirm. It was IA 15.
15.
15. IA 15 of 2025. The DP Nanda, Senior Counsel, in response to the submissions of Mr. Mukherjee, and Senior Counsel. Though defendants find flaw in not mentioning the Gujarat suit in the plaint, but what no? In the plaint, as well as contain that the suit before this court is in aid of the suit pending at Gujarat before the High Court. Section 5(1) of the Admiralty into bracket jurisdiction and settlement of maritime claims bracket closed Act 2017 itself gives the answer to the said proposition. I1 portfolio. It is submitted that quotation for it. It is submitted that since the section 5(1) refers to an admiralty proceeding, a suit before this court is also in aid of another suit, and the vessel and the claim is the subject of an admiralty suit pending in Gujarat. We submitted that it is for securing the claim at Gujarat also securing the value of the property, that is vessel, that is being sought for in the suit at Gujarat. We submitted that reliance upon the defendants, reliance of the defendants on African eagle has to be considered in the context of African eagle is a pronouncement prior to the 2014 amendment.
2017 Act.
2017 amendment.
Act. Not amendment, Act.
2017 Act. The learned senior refers to Altus Uber. Para 37 onwards. To submit that the observations of Altus Uber in paragraph 37 onwards of the SEC print, that is SEC print, I think. Yes, SEC print. We will go to show that African eagle was rendered in a different context prior to the 2017 amendment. You can take your seat. Whenever you can stand up. No.
Okay.
Responding to the contention of the learned senior counsel, Mr. Mukherjee, that defendants in the present suit before this court are not party before the Gujarat suit, before the Gujarat High Court. Gujarat High Court in the pending suit there. So now the submits that the defendants do not dispute. They are the owners of the vessels. The vessels have been named and are identified being subject matter public party of the present suit before this court. Referring to the Court Fee Act, Court Fees Act, Court dash small f double e s. এটা দেখি লিখুন না, Court Fees Act দেখি লিখুন। Here. The Court Fees Act, Section 17, Section 7. That is computation of fees payable in certain suits. Mr. Nanda relies on 7 into bracket small Roman 4 IV, 7 into bracket IV, bracket closed, small c, that is for a declaratory decree and consequential relief. D, small d, small d into bracket small d for an injunction and small f into bracket small f for accounts. 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 Referring to the response of the London Senior Counsel, Mr. Mukherjee, regarding the scope and applicability of Order 7 rule, Orders O.7 R dot dash into bracket small a. Is submitted by Mr. Nanda. Order O.7 R.11 dash into bracket small a provides that if the plaintiff does not disclose a cause of action, it shall be rejected. And in the proposed amendment, the cause of action is disclosed. Then para. It is submitted by the Senior Counsel, Mr. Nanda, that regarding valuation of the suit, it is the plaintiff who will value the suit. On the said proposition, he relies on judgment of the Supreme Court reported in Sri Ratna Varma Raja versus Vimla. Reported in AIR 1961 SC 1299 into bracket SCC online print. Paragraph 2, 3. Referring to paragraph 3, तापर लिखंतु paragraph 2, 3 कोट हे गला तापर SCC online में copy paste कर दो. It is submitted that. The anxiety of the legislature to collect court fee from the litigants do not arm the defendant with a weapon of technicality to obstruct a suit. Coming up, the learned senior counsel files a memorandum indicating the issues proposed to be answered on behalf of the plaintiff. The said issues are reproduced here. এটা এটা হলো আপনাদের রত্নাম্বর এটা হচ্ছে ইস্যু. So, Pati, anything else?
No, you're covered.
Today, Mr. Mukherjee did not submit anything, or he did.
No, he did not submit.
Because I started having this what is called deja vu or something like that.
No, he hasn't
I still
submitted.
think Mr. Mukherjee is on his legs, and
No, yeah.
Mr. Nanda is on his legs. Then IA 9 of 2025. Mr. appearance ଆପଣଙ୍କର ଅଛି ଯୋଟା first title ଯାହା ଅଛି ସେଟା ସେ କହିଲା ସିଟେଲ ଚେକ୍ କରିଦେବେ ଏଠି appearance Mr. Saryakanta Padi, senior advocate, along with Mr. Ipsit Arvind Acharya for the intervener. At the outset, Mr. Padi submits that he doesn't have to make any submissions in response to the submissions either by Mr. Nanda on behalf of the plaintiff or by Mr. Mukherjee on behalf of the defendant. But since it is admitted that the property involved in the present suit, that is the two vessels, are mortgaged to the petitioner intending intervener, his substantial rights have been his substantial rights are involved. The result of the order in the IE arresting the ship has directly impacted the mortgage property. He submits that since at the present stage the court is is grappling with the issue. Grappling is the correct word, Mr. Padi. Court is grappling or court is deciding or what? Or dealing?
What is, I would, most appropriate would be vexed with this issue. Grappling is a right word.
The court is grappling with the vexed issue of whether the plaint is allowed to be amended, whether court fee not being paid, the plaint is to be rejected, whether as a consequence, if at all the amendment is allowed, what would be the valuation of the suit? Then whether on allowing the application for amendment, the court fee suggested by the plaintiff would be accepted as the correct valuation. He may not have arguments as far as the intervention application is concerned, as pendency or otherwise of the suit is debated. However, the intervener's contention for the present would be confined to the issue raised in the IA for amendment. He submitted that the amendment to be allowed has passed the scrutiny of the tests laid down in LIC Supra. On LIC of India versus Sanjeev Builder, agora both jagare achi. Senior counsel refers to paragraph 71.4.3 and 71.4.10. The upper quote quoted in order dated कर कि मैं quoted कर already
71.10 71.10 and 71.4.3. That's what.
Yes.
In
So
71.
in page 35, it is 71.4.3. The prayer for amendment is mala fide.
Yes. Changes the nature. 71.4.2, nature of
Yes.
suit. Same thing. Amendment changes nature of suit. 71.43, prayer.
Then 71.10.
10, yes.
These two paragraphs.
Yes.
Referring to then subparagraph referring to those paragraphs, the party lawyer senior submits that the court has to see whether the proposed amendment is afflicted by mala fide and whether the nature of the suit or the cause of action are changed and whether the case set up in the proposed amendment is foreign to the case set up in the plaint. So, to give an instance, he refers to the original plaint where there has been no reference to any pending Admiralty suit before the Gujarat High Court, whereas in the proposed amendment, the issue is all about the Gujarat the pending suit before the Gujarat High Court. It is submitted that not mentioning the pending suit before Gujarat High Court, pending Admiralty suit before the Gujarat High Court could be deliberate. Regarding the valuation, also, the Learned Senior Counsel refers to the plaint paragraphs 12 and 13, where I know to submit that the plaintiff themselves value the suit at 598 crores, whereas in the proposed amendment, they value it differently. Purportedly being in the aid of the suit pending at Gujarat. Mr. Mahanti, Mr. Padil, that much?
Yes.
Mr. Mahanti, Learned Counsel, appearing for the plaintiff. Appearance of perhaps. Mr. Sambit Mahanti, SAM VIT. Sambit Mahanti, Learned Counsel, appearing for the plaintiff, refers to Mr. Mahanti, Order 6, Rule 17.
Milord. Order 6.
Refers to Order 6, Rule 17 of CPC. To submit that the amendment shall be made by this court, shall be allowed by this court, that may be necessary for the purpose of determining the real questions in controversy between the parties. He highlights the term parties who single quote PIES. As you were told, Lakos to be aware of it. To submit that the intervener not being yet a party in the proceeding, there is no scope for entertaining the contentions of the intervener. It is submitted that the submissions of the Learned Senior Counsel regarding mala fide, change of mala fide, change of nature and character of the suit are already on record, and those will be the answers to the contentions raised by Mr. Party, to the arguments made by Mr. Party, Learned Senior Counsel. So that concludes the hearing. Hearing concluded. Judgment reserved.
Yes.
Actually, initially I was thinking that it can work out that if it will be pronounced in open court, but now
time.
So no, tomorrow this bench will not function.
Lord, you have already recorded everything.
So that is how it will take.
Just one thing, Lord.
Yes, Mr. Mahanti.
That I had also one point, Lord. The intervention application has no pleading to our objection to.
See, Order 6, Rule 17 पूर्व लिख दियो तू. That now you are provoking them to file that and tell that you cannot file. Like they have been all through provoking that why you are not filing, why you are not filing. Because they make it clear that since that we are yet to intervene or our intervention is to be allowed.
I know, Mr.
And because we are only watching the stadia, watching the more like a audience than a player. So to that limited extent. But to be frank with all of you, it has been always a pleasure for me to hear Mr. Padhi.
Me too, Milo. I always do that.
He has been so kind.
And we put
The notice was issued. Last occasion, AD was not returned and the lordship directed to place the tracking report. And the noting is today, lordship, the list. Notice and admission matter issued to the sole OP by restitute with a day.
Not known, Mr. Barad, have you examined that CC Alavi Haji versus Palapati Mohammed, those 3-4 decisions? How the Supreme Court has held regarding not known?
Not
I hope. So let it come after vacation. You examine whether on the postal authority reporting that not known. This can be, it can be treated to be sufficient. So you examine those decisions because it will require some time. Because like addressee left without intimation, that will be sufficient. Same address given in the first title of the suit, it will be sufficient. But interestingly, yesterday in a matter, the address given is Sushanta Kumar Barar, Outpost Town District, Cuttack. In the plaint, the argument by Mr. Baral is that it is sufficient. So then I asked Mr. Baral, will the postal authority find you at Post Town District, Cuttack, simply Sonpur, at Post Sonpur, District Subarnapur. This is the address given. So we have issued notice. Notice has gone. The postal authority has returned a note. Address insufficient. So that is also another issue because I think simply saying that at Post Cuttack District, Town District, at Town Cuttack District Cuttack is sufficient address.
Here,
Mr. S.K. Barar, sorry, yes.
Here the address given, two address, the permanent address and the present address. Permanently that award is at Jajpur lordship. But in the Bhai Pakre Rahuchi Boli, culture address the case file करचंदी. Notice was issued in the present address. But if your lordship permit, then we'll take notice in the permanent address.
Apana better huchi repeatedly. Suppose you are having that definite instruction that it will be sufficient, then you take notice.
Yes.
So
on that score, after vacation or similar.
So it will be before or after vacation?
After vacation.
After vacation. So otherwise, simply issuing notice again and again, only time is wasted and no result is achieved.
Pendency of this application before the Honorable Court, it is within the knowledge of the OPLRship. As because why I am saying, the stay order granted, that has been placed before the court below, and in view of the stay order, the matter is adjourning with copy to the council appearing for the OP.
So may I direct that it will be served through the court?
Yes, Your Lordship, that can be.
The Learned Counsel appearance that is Mr. S.K. Barar. Mr. S.K. Barar for the petitioner. Opposite party blank. Learned Counsel for the petitioner refers to the office note put up by the registrar regarding sufficiency of notice. office note dated 5/20/25. So by the registry is quoted herein. Notice on admission matter issued to show Loki up to on behalf of opposite party. But earlier the order dated 23/4/2025, registry was directed to verify if any learned counsel has appeared. Accordingly, the note indicates that तारीखटा केते थिला नोट हम जोटा लिखले आज on 6/5/2025 no learned counsel has entered application on behalf of the opposite party. The learned counsel for the petitioner submits that the order interim order dated 13/3
My lords, dated 13/25.
dated 13/3/25 regarding filing of granting liberty 13/25 granting liberty to the petitioner hearing for deferment of the proceeding in MAT number
72/2024. Learned senior civil judge Talcher Lord. Senior civil judge Talcher. Adjourned to 26 June LRC. My lords. My lords.
Sorry, I think the audio was off.
Yes.
He's aware of the present proceeding before this court. The learned counsel seeks leave to serve notice of this proceeding through the learned court. That is learned court in season of MAT number 72 of 2023. Leave granted. Requisites for issuance of notice be filed in the registry that will be forwarded to the court. That will be forwarded to the learned senior civil judge to the court of. That will be forwarded to the court of learned senior civil judge Talcher. The notices shall be served on the learned counsel appearing for the petitioner as well as to the petitioner in person. The service written as would be received in the said court shall be forwarded to this forwarded to the registry of this court to be placed on record. Since the next date of listing before the learned court at Talcher is
26 my lords. 26.
26/6/2025. The notices can be served on the said date on the learned counsel and thereafter on the petitioner. Registry to do the needful. List on 10/7. Now to other time said 26 is the last week in fact.
Yes.
Because list on 15/7 करते 15/7 अपन requisites केबे सुधा दे देबे
by tomorrow
through court process जोटा जीवा अपन जो लिखले requisites be filed
the unutilized
within 3 working days कर दो 3 working days, not 5 working days.
Unutilized copy we use your lordship. Only process fee you have to.
Whatever. ଆପଣ ସେଟା ବୁଝିକି କେମିତି
Yes,
କରିବେ?
yes,
Be filed within 5 working days.
my lords.
Unutilized requisites that can be utilized shall be utilized for the purpose of sending. Shall be utilized or stop करेंगे. Shall be utilized.
Interim order continue.
Interim order dated 13/3/2025 shall continue till the next date of hearing.
Oblige.
11.
Item 11, my lord, last occasion I have taken time, 2 weeks time granted to me to obtain instruction from the petitioner. I seek one more week time to obtain again instruction of the petitioners, because some of the petitioners have already retired from their service and some have showing their eager to contest in this case. But till now they have not contacted with me.
Mr. S. Mahapatra.
Yes,
Mr. S. Mahapatra for the petitioner. You are there, sir?
We are instructed to appear for the Director Walmi, opposite party number 2 in the writ petition, and
You are appearing along with?
we have not filed yet our Bakalat.
I understand, but
Yes, my lord. For Director Walmi, opposite party number 2.
Mr. Devaraj Mahanti AG for opposite party 1. It's a president, so he's not appearing. President Walmi, you are appearing.
Yes.
So sir, लिखित है तो
Our power is not there, my lord.
it is submitted by आपन का नाम है
Jyotirmay Barik. My
J. Barik?
yes, my senior name
along
kindly
with
be reflected.
Mr. D.N. Dayananda Mahapatra.
Yes, senior.
Dayananda Mahapatra, senior counsel, submits that they have instructions to appear on behalf of the opposite parties 1 and 2.
2-1.
They may be granted time for filing Wakalatnama
Yes.
and appearance memo of the senior counsel.
My lord, I am appearing for opposite parties 3 to 6. Private office 3 to 6 in the main writ petition.
Upon Wakalatnama file cut?
I have also filed my counter.
So what is your name, sir?
PC Patnaik.
PC Patnaik.
yeah.
Mr. PC Patnaik. Name is not there.
My name is there in the list.
Okay. Achi.
List achi.
Kitna number item? 11.
PC Patnaik is there. Item
So
number.
PC Patnaik
Yes.
for OP?
OP is 3 to 6.
OP 3 to 6. Purnachandra Patnaik.
Padmacharan Patnaik.
Padmacharan Patnaik. So Padmacharan Patnaik for opposite parties 3 to 6. Appearance in a son. Submission of the opposite parties on letter. Tapar lekhantu Mr. Mahapatra appearing the learned counsel for the petitioner submits that he may be granted further time to obtain instructions from the petitioners on consent list on date करूँ 9/7/2025.
12.
12 millers, I prefer 2 weeks time to file counter.
Yeah, please, my lord.
For the state.
Mr. Jagatjit Panda
My lord.
for the
The unfortunate petitioner, my lord, is praised for the regulation and constitutional benefits. From 2013, now the government is saying file a counter.
Because Paraj government has received it to be filed.
She was
That means last chance.
she was initially engaged as a community organizer in Kendrapada municipality in 1994 against a sanctioned post on ad hoc basis and continued there, my lord. And superintended on 2009.
for executive officer, you are
Yes.
appearing.
I'm happy. Yeah.
Mr. Devaraj Mahanti, appearance देख लेंगे. Devaraj Mahanti for opposite parties 1, 2 and 3. The Sudhir Patra is there, standing counsel, accountant, general. Mr.
Second and
Patnaik, Mr.
pin number 4.
Mr. Patnaik, you are along with Mr. Misra? Or you are along?
Yes. Opinion number 4.
Opinion number 4, you are Mr. T. Patnaik?
Yes, please.
Mr. T. Patnaik, along with
D. Patnaik.
D. Patnaik.
D. Patnaik.
D.
Patnaik. Mr. Manoj Mishra, Senior Counsel, along with Mr. D. Patnaik for OP4. The Learned AGA seeks further accommodation to file counter on behalf of the opposite parties 1, 2, and 3. Mr. Ponda, Learned Counsel for the petitioner, submits that the petitioner is waiting for regulation since long, and now she is aged about 72 years.
Yes, my lord.
Now, how she will be regularized?
My lord, as for the present decisions of this Hon'Ble Court in 2014 and subsequently followed, they have stated in division bench that one day it is to regularize and pensionary benefit has been given. That is only my prayer. 2014 division bench of this Hon'Ble Court
It's
has said,
submitted that the petitioner can be regularized for a day, and so that she gets the pensionary benefits.
yes, my lord.
Para. Mr. DG shall also obtain instruction in response to the submission of the current counsel for the petitioner regarding regularization for a day to entitle or for pensionary benefits. Mr. Patnaik for the OP number 4 are also, but that is according to a scheme formulated by Supreme Court.
Well, no. I can cite it, those doesn't followed by the also, by the single bench of this Hon'Ble Court.
I understand, but anyway,
Let's see, my lord. Let's find out.
List, yes. List
2014 one will
So 2 सप्ताह आपण हाते तो
next week, sir.
4 दिन अछि आपण पाखरे 2 सप्ताह को छाडी
734.
4 7
Sir, in June रे ହେଇପାରିବ କି sir?
जून रे तो 4 दिन समुदाय अछि आपण
से
आपण आफ्टर वेकेशन हां नो ना
नहीं जदी सर एई भीतर ही पाला तो
not possible.
not possible 12 वर्ष देना
In fact, the next week, in fact, there is no day, no
next
space
week
for
sir जाऊनी
anything of any matter.
सर जून रिओपनिंग पर किछि डेट सर देख परिबे
आपनकर रिओपनिंग पर से कते 4 ना कते कहले आपण और रिओपनिंग पर से थर्ड वीक कहै छथि
हां सर
not much
26 तारीख जून 26 जून
26 20 25
26 जून सर कर दो
26 20 25
it this says what benefit will get I don't know, but she is crying, that's why.
Provided if
there should not have been kept pending.
No sir, ko
This is a classic case where you should not have kept it pending.
should not be pending. Actually sir mo file ta miss hela mutla ghara shift kali filing totally file ta sir mo bandha hi poralani upur ku khoji ki bahar kale, then it was been mentioned many times mention hela pare 2013 matter my lord come out in state. Sir, June 26 sir.
26 6 पर कहले 26 6 राइट
13
My lord,
13?
item
Yes.
13, my lord, on behalf of Mr. Rath, my lord. My lord, the matter is ready for hearing and memo citation.
No, you are for the petitioner.
Yes, my lord, I'm for the petition.
What's your name?
Indira Priyadarshini Bose, on behalf of Mr. Rath, sir.
This matter, my lord.
Mrs. I Pradhan, Indira Priyadarshini Pradhan.
Indira Priyadarshini Bose, my lord.
Miss I. Indira Priyadarshini Bose on behalf of Prafulla Kumar.
This matter, my lord, is dragging since 2004, my lord. This matter, the certificate case was, my lord, order was there. He did not prefer appeal by filing the, my lord, paying the fees. He challenged that order here. Again, my lord, without filing a revision, he, my lord, got an order that he will file review. In this process, my lord, they are, my lord, lingering the matter, and I am the auction purchaser, my lord. I have purchased the property by paying the entire amount.
Yes.
He has not paid a single dues till today, my lord. If he is interested, my lord, let her deposit something, my lord. Without depositing, my lord, lingering the matter since 2004 year in 2025, my lord. And I have purchased the property in 2018, my lord. And is a Lordship fixed date. I have no.
You are for the OP6.
OP6, my lord. I have no objection to your Lordship fix a date, but this is how this matter has been dragged since long, my lord. One after another writ application has been filed.
Counsel,
kind permission.
Counsel appearing along with the senior counsel for the petitioner. 6 time accommodation. As the matter is, since there is paucity of time, the matter cannot be heard today. Mr. Jadipal, Lord Counsel appearing for the OP number 6 submits that the OP number 6 is the purchaser of the property, auction property.
Madam.
Auction by?
Auction by the collector?
Auction by the OPDR authority.
Yes, ma'am.
OPDR.
That collector.
By the OPDR authority. Since 2004.
18, my lord.
2018. About
2018.
Auction in 2018. The petitioner, without depositing any amount,
I purchased in 2013. Got possession in 2018.
2013. Auctioned in 2013. 18 months. The petitioner, without depositing any amount towards the what was the decree or the due?
They have 72 lakhs was deposited way back 2013.
No, the certificate was for 70 lakhs, my lord.
Certificate was issued for which, what demand?
For demand of the OPDR demand for auction of oil mill and land.
72,000.
72 lakhs.
72 lakhs, 15,000.
Was
the
deposited.
certificate dues? Post auction.
Your Lordship
The
may
matter has been lingering.
Your Lordship may indicate after the sale procedure 27, 28.
Sir, nothing could be indicated in the last 12 years, and today I will be indicating everything.
No, sir, my lord, this matter
That is very interesting, Mr. Misra.
My lord, in
For the
2000,
12 years also, the writ petition of 2000, since 2013, nothing.
my lord was dismissed. My lord was dismissed in 2018. Because
my lord is yet to be dismissed. My lord will continue for some time.
no, my lord was pleased to dismiss the writ petition.
Yes.
Observing that
So you said my lord was dismissed, so that is how I say.
No, I know. Well, at 2018 writ petition was dismissed.
So after 2019, still 6 years. So nothing could be done. Now today it will be done. So at least for the vacation, nothing would happen.
Let them deposit that.
The learned council submits that the date may be fixed. Mr. Misra, learned council appearing for the
In WPC number 35582 of 2020, last item, Lord, I am also the
property.
No.
Same auction
He is
purchase.
appearing for the same auction purchaser.
Achha.
He has filed another writ application. After purchasing property, he is not the road
access was
approach road. For that, he has filed a writ application.
So approach road, High Court will give that.
No, my lord, they have concealed. The certificate that Lord had concealed. So collector is yet to give me a passage to that property to access because already position was given.
Appearance तो ताले बहुत उड़े अच्छी अपन को.
I can say
Certificate to be registered.
Yes.
So therefore,
Possession given.
therefore mutation case has been rejected.
Your lordship may indicate my
WPC 35582, Mr. Lalitendra Misra. Add कर देबे. In all of the cases, Mr.
I'm
and Mr. Ratha, you are madam appearing in all cases.
Yes, all other writ application, Mr. Ratha is appearing for the petitioner.
Like add करके जिबे. Consent to गोटे करी order करी लो.
your lordship permitted to hearing.
Yes, madam, suggest a date. Your seniors are after 12 years, they are really anxious for hearing. Especially Mr. Misra. Subhuni, Subhuni.
After vacation.
After vacation, my lord.
Date करंतु after vacation जते जल्दी ही करी. 7
हो गया.
कोन टिके appearance उडा का जहाँ छी. So appearances are reflected in the cause list अपन.
Yes, reflected.
All petitioner by Mrs. Bose, Mr. Ratha along with Mrs. Bose. Yes.
Lordship, one section 27, 28, 29 application have not been filed to set aside the sale.
अरे जाओ सेटा सेना आर्गुमेंट हो
मेरिट रे करिवे केबे
ମୁଁ କହୁଛି ଆଜ୍ଞା କେମିତି ସେ ଆସିଛନ୍ତି ବିନା ଡିପୋଜିଟ ରେ without my senior brother
12 ବର୍ଷ ଆପଣ 5 ବର୍ଷ ହେଲା କିଛି କରି ପାରିଲେନି ମାନେ ଆପଣ ବି 12 ବର୍ଷ ହେଲା କରୁଛନ୍ତି।
Mr. Ratha and Mr. Sharma all are
My lord, there is an interim order, my lord,
interim order
regarding status quo.
interim order dated any idea
2019 रे पास after dismissal it was earlier there
13, my lord, 11/6/13, my lord.
13 after dismissal it has again revived.
the interim order passed earlier shall continue till the next date of hearing.
13
Put in Mr.
I am for the open number 4.
Yes. Who is for जो आपण जोटा एबे अर्जन कलेनी जोटा अपियर करथिले मिस्टर पाल रे स्टेट रा अपियर की करथिले लिखिले and document. So Devraj Mahanti AGA for opposite parties 1 to 5. Or else you can do one thing. प्रथम ऑर्डर कर देले तापर कोन लिखि दियो तू in view of the order passed in so and so list on it. But appearance has to change. Appearance Mr. Mishra is in one matter.
Item 14
Petitioner none, Mr. Devraj Mahanti AG. For Devraj Mahanti AG for opposite parties 1, 2 and 3.
Yes.
Mr. Prosecution Jena along with Mr. Satyajit Behra. You are appearing or Mr. Jena is appearing?
Mr. Jena is appearing.
Mr. S. Behra for the OP number 4. None appears for the petitioner when the matter is called. To grant further opportunity, list on 9/7/2025.
15
May I please?
Yes, 15.
My lord.
Mr. H.P. Das.
My
H.P.
lord.
Das for the petitioner. What was the last order, Mr. Das, or it is coming for the first time?
नहीं लास्ट ऑर्डर थिला अथरा कॉपी गोटे नेनथल बोली स्टेट नेनथल बोली गोटे कहितले स्टेट को से दिन सप्लाई करा हिची
अथरा थिला जे whether there is any provision for appeal or not. He has directly approached the honorable court without availing the appeal provision available to him. Departmental appeal available to the petitioner was not availed of by him before approaching this honorable court in this present writ petition. The rule 5.
You have kindly just look at that order. Order dated 21/4/25.
Annexure 6 and Annexure 7, my lord. Yes.
Order dated 21/4/25. Last order.
ठीक है.
6 रे आसीबो आपण सेट देखु नांती ना अछि आपण पाखे. Just click that order in that
The learned senior panel counsel shall obtain specific instruction in response to the submission and apprise of the court. It is submitted by the learned counsel for the petitioner that petitioner is aggrieved by the order dated 27/7/16 issued
You are reading something, madam.
the
Order.
last order.
So yes, you have an answer to that.
Yes, I have taken instruction from the CRPF authorities.
So you have a copy of that.
Yes, I have given
How to look at that? You have to provide a copy.
opposite party. Central Civil Service Temporary Service Rule अनुसार अच्छी तंकर appeal. Second, Rule 28 and 29 of Central Reserve Police Force Rules 1955. I have already
Served a copy.
Not audible, sir.
I'm so
Sorry. कौन सी कुछ?
No, so I'm sorry.
शुक्ला हाँ.
ମୁଁ ପାଣି ପିଇଲା ବେଳେ ସେଟା ଅଫ୍ କରିଦେବି. So the order is that she has received instruction, files a memo, copy served on you, and
yes.
And once the senior panel counsel, you must understand that you are saying that there is appeal provision. Now you cannot take a plea that he cannot file appeal. That is also there. Let him file appeal, and you can consider.
Yes, sir.
Today it can be disposed of, or let him take instruction. Yes.
Another date may be fixed.
Sorry, ऐसे कहिले 11/7 आपण এটা মাইক্রোফোন রে কোন না 11/7
11/7
16
16.
Prabhu's matter, my lord, he has sought for adjournment, my lord.
My lord, I'm there, my lord. Lordship has directed me to file an additional affidavit whether in the counter 80 point roster has been referred or not, my lords, and it has not been mentioned.
I didn't direct actually. That
My lords, I had prayed for.
So you were fair to say that actually that has not been dealt in the counter.
Yes, my lords, yes. So, my lords, I need
so
some more
obviously
time to
that
prepare.
cannot be treated to be a concession. So obviously time. So you have obtained instruction.
My lords, I need some more time to prepare, my lords.
Because Mr. Samir Kumar Das for
I have requested my learned senior
Mr.
to.
Prabhu Prasanna Behra, Additional Standing Counsel for OPs 1 and 2. Mr. T.K. Patnaik for OP 3. T.K. Patnaik, kile kore gale. कही देवे ताले the learned counsel Mr. The learned counsel for the petitioner refers to the order dated 24/4/2025 to submit that state had taken time to the opposite party state had taken time to file to obtain instruction the learned additional standing counsel in response submits that he has sought for instruction which is yet to be received and may be accommodated further. As prayed for, list on date karantu 10/7.
I'm mobilized.
17.
Lord
So
here.
So SK day for the petitioner?
Yes, Lord, I am there for the petition. It is for non-payment of the compensation amount in lieu of acquisitions of our properties as back as in 2012, my Lord. The High Court, the Hon'Ble Court of Reference, passed the order on 19/9/80.
So there one difficulty would be that since it is a 22 petition filed way back in April 22, exactly 3 years have passed. So the opposite party would have changed. So you can take help of Mr. Mohanty to find out.
Not that they had taken time on the ground that they have filed special petition.
SLP is pending, still pending.
But there is no stay, my Lord.
Whatever it may be, you have to bring the proper party on record. That is for that in a quasi criminal proceeding like contempt, unless the proper party is made, court should not proceed. Regarding merit, definitely they have to obtain instruction, obviously. They have to. So you obtain instruction and make the proper party.
And that I will do, but your Lordship, may I ask them to.
So SK day for the petitioner, Mr. Devraj Mohanty. AGA for the opposite parties. The counsel for the petitioner submits that he shall obtain instruction regarding the present incumbency of the opposite parties in different posts of the government and shall substitute them in the petition. The learned AGS submits that he has sought for instruction regarding the present status of the SLP pending before the Supreme Court, challenging the order of this court in LAA number 80 of 2019. ठीक अछि तो?
Pending अछि. That been still pending. I have checked it out. That's pending.
That been
accommodated
to obtain stay, my Lord, just for the sake of compliance.
I understand, but the problem is that once SLP is brought to the notice of the court, prudence demands that it should be adjourned at least.
No, my Lord, that is what the court says.
Still then, you have to bring the present
that I will do, your Lordship, that I will do.
You do your part. Let us see what is happening. Don't be impatient.
Your Lordship knows in several decisions, the courts, your Lordships even have held that filing of a special petition doesn't amount to stay, my Lord. The Supreme Court has
specially petition if it has been admitted and a civil appeal has been made.
Notice has been issued and
notice has been issued, then it is different. There are several decisions of the Supreme Court also. For instruction. First for instruction regarding the present status of the SLP. The matter may be urgent. List on 14/7.
14.
Who? Sabudakar, same order, Mr. Day. Sorry, I have to call you back. You substitute the present incumbents so that it will be easier for Mr. Mohanty also. Obtain instruction. So rest of the matters goes out of the list, cannot be listed further, except those adjournments.
My Lord, pardon, my Lord.
18, my Lord.
Item 39, my Lord. PRPC is there.
Item 18, my Lord.
That is a phrase matter.
So I am saying beyond, say item 19 or 20. This page is 19. So I'll finish it here.
18, my Lord.
Yes. I'm saying that informing the learned members that beyond this item 19 or 20, I will not go beyond this. And the list cannot be continued because of paucity of time.
Just
next year, the next week, almost every day, there is about 40 matters.
I may be pardon me on item 30.
No, adjournments can be made. Already I have adjourned, I mean, some mentions were made. And I have
my Lord, item 39 is a phrase matter, my Lord, because of Mr. Joseph appeared in caveat. So it didn't come in admission matter, my Lord. It's a phrase matter, my Lord.
39 तो आपणकर
TRPC.
कैविएट हेले आपणकर पिछले ऑर्डर से आसीबो ना कैविएट डिस्चार्ज हे जेती कैविएट डिस्चार्ज हे
It's a fresh matter.
I understand, but the caveat पर कुछ ऑर्डर ही तो
नहीं FPR रहती है तो आप पर release पे
there you are correct. The date it should have come for fresher orders. Next week रे कर दियंतु orders पे.
Yes.
Item 53, my lord, I am for the opposite party.
Page wise adjournment. Nothing, no more orders, no more hearing. I will not be, this bench will not function tomorrow. In fact, today is the last day of the week. Achha, that I did not.
Item 18.
I may be pardoned.
My lord, item 18.
Item 18.
It's similar content matter. Single judge has.
No, item 18, 19, I'll take up. Just be patient. Since everyone is waiting for their matters, so I prefer that it should be informed.
My lord, I may be pardoned. My lord, item 30, my lord. His prayer may be, I am for the opposite party. His prayer may be allowed.
Page wise. Page 6 रे जोटा आपनकर adjournment जोटा अछि.
Page 6 रे 21 टा ढोका है.
ମୁଁ ଜାଣିଛି sir. So anyone present, those who are waiting here, so that I
22, 23.
Item 23, my lord. I am for the opposite party. My lord and friend is there, the petitioner,
Yes.
my lord. That is the transfer. Let it come after vacation, my lord.
Mr. Misra. Mr. Misra, you are there. Item 20 is mentioned. 23 is mentioned. 23 RR Misra. Jain Ponda.
Ken Ponda.
Ken Ponda.
Malad item 20.
कितने को ले?
एक साथ.
नहीं माइक्रोफोन में कौन तू? एक के साथ है.
Obliged.
Malad item 22 after vacation interim order is there. Malad.
Interim order जो थी रची simple adjournment रे it is not going to be varied.
Obliged.
So it gets you want a date or what?
Any date after vacation.
Mrs. Das.
So I am also present for the opposite
Yes,
party.
Das for the petitioner. Opposite party में क्या?
Sir, Vibhuti Patnaik, sir.
Mr. Vibhuti V. Patnaik. 22 तारीख. माफ करो तुम. Shephali Das, Vibhuti Bhushan Patnaik. Mr. Barik, give a date.
207.
Obliged.
10 sir. Mr. Banerjee.
Is 11 item 30 million.
नहीं साथ. We are at page 7. Just give some time.
Item 24 to 26.
Item 21 टा डाकी दियो. सर ये इसका closed. हाँ.
24 to 26.
नहीं 26 to page 7. 24 to 29 वाला.
24 to 29.
अपन को Mr. Muthuljay
Item 30 million is a transfer petition. I am for the opposite party.
सेटा अपन को ऑर्डर सकाय डका है कि कंप्लीट है पेंडिंग रखा है ये लास्ट तो रही जाउची गुडे 30 Mr. Mrityunjay Banerjee for the opposite party. Petitioner thank you.
I am Parsuram Panda.
Mr. Ponda.
What a pray, my lord, his prayer may be allowed. What a specific date may be given for disposal of the long since the matter is pending. The petitioner has earlier filed diverse petition and after filing of the returns.
In view of the appearance section 30 P Ponda, Parsuram Ponda, Mr. Mrityunjay Banerjee. The matter is taken up on mention as the Lord counsel for the petitioner submit that the parties have agreed for disposal of the matter by allowing the prayer of the petitioner for transfer of the CP number, CRP number, not CP number.
CP number 266 of
CP number 266 of 2024. Pending in the
Court of the Family Court Puri.
Family Judge Puri to Family Court number 2 Bhubaneswar. Family Court number 2 is overburdened. Puri is a better place. Family Court number 1 and 2 because of the number of marriages at Bhubaneswar, the territorial jurisdiction is huge actually, huge. collect, so, could sign that? Transfer of funds, full stop, full stop. It is submitted by the learned counsel, Mr. Ben, for the opposite party that he shall move the court for expeditious disposal of the matter. If any application is made before the learned court of family judge number 2, court, should I call it family court number
Family
2?
court number
Family
2,
judge number
Bhubaneswar.
2. Court head,
Family court 2.
Family court 2,
before
Bhubaneswar.
the family court 2, Bhubaneswar, the same shall be considered. And appropriate order shall be passed regarding expeditious hearing, depending on the pendency of other matters before the court. It is also directed that as far as the proceeding before the court is concerned, both the parties shall cooperate. The court shall not grant any unnecessary adjournments. The petition stand disposed of.
Transfer.
Sorry?
Seeking transfer is allowed, Your Lordship.
Allow hegala to Mr. Who could allow police? So Banerjee allow करते
My lord, why is submit me, lord?
ଆପଣ ହଉଛନ୍ତି husband ନା wife?
Wife.
ଆପଣ husband allow କରିଦେଲେ, so what is that?
Earlier, me lord.
ଆପଣ ସୋନାଲିସା ରଣସିଂହ
Sonal Ransi.
ଲୋକନାଥ ରଣସିଂହ allow କରିଦେଲେ, ସେ ଖୁସି କହୁଛନ୍ତି ଯେ ଆପଣ ଆସନ୍ତୁ ଏଠି କେସ୍ କରିବେ ବୋଲି।
May I pray for
It will be better that if you file a petition for reconciliation and the one day
Chance ଅଛି.
so
Chance ଅଛି. କିନ୍ତୁ
conciliation?
it is also stated by the Lorded Council for
Conciliation
the
have been
appearing
failed.
parties, husband and wife, that there is chance of
No, my lord.
resumption of the matrimony. It is hoped that all out efforts shall be made for reconciliation and resumption of the matrimony.
And one thing, earlier, my lord, wife has filed the case for divorce in 2020. It kept lingering. କହିବା ଦରକାର ନା କୋର୍ଟ କୁ ଆଜ୍ଞା କୋର୍ଟ ଆଡଭର୍ସ ଅର୍ଡର ବି ପାସ୍ କଲେ କୋର୍ଟ ସହିତ ଆଇଡେଣ୍ଟିଟି କଲେ।
Mr. Banerjee, I have some difficulty in forgetting. I still remember your last submission. So that is besides the issue. So you are, since she earlier filed the petition, your petition should be this time allowed. Now she is saying that you can withdraw your petition.
correct.
She has already
So
withdrawn.
that is the best part for the lawyers.
She has already withdrawn, my lord.
The wife comes. you
She has
file the
already
petition,
withdrawn.
Then she withdraws. Mr. Panda is happy.
No, she has
Now
already
the husband
withdrawn
comes, files a
during the
petition
time of hearing.
and tells withdraw. Mr. Banerjee is happy. Now there are 2 TRPCs filed in High Court. Mr. Mahanti is happy, and so all learned counsel are happy. That's the best part of it. Yes.
Banerjee is the most.
Well, I don't know 38 after vacation entry order
Correct. Page 9 de ki arjan karibe only dates. Item 38 apanakar. 38 you are Mr.
SK Mohan.
SK Mahanti for the petitioner. So to opposite party to nahanti. Opposite party blank se rakhi. The learned counsel for the petitioner. As prayed for by the learned counsel for the petitioner, list on what a date got you. 10/7.
Fine. Entry order to continue.
Entry order dated so and so shall continue till the next date of hearing, liberty to mention for listing before the assembly.
My lord, item 37, Lordship.
37.
TRPC, my lord. Actually, there is an interim order.
Mr. Prince Patnaik for the petitioner. Opposite party, anyone there?
Lordship, name is indicated this time around, but
Opposite party blank. ଟିକେ shorter date ଦିଅନ୍ତୁ ଯୋଉଥିରେ party ନାହାନ୍ତି of course it should accommodate it in your list, but Mr. Pravin Das opposite party blank कर दियंतु as mentioned by the learned counsel for the petitioner, the matter is adjourned to quick date କରନ୍ତୁ 26/6 नहीं ମୁଁ 26/6 ବୋଲି କହୁନି ଆପଣ ଦିଅନ୍ତୁ but not ଆପଣ ଆରଟା କେତେ କେବେ କୁ ଦେଲେ ମିଷ୍ଟର ମହାନ୍ତିଙ୍କର ଗଲା 9/7 ହଁ ଏଟା ସେ ପାଖାପାଖି 9/7 କରିଦିଅନ୍ତୁ 9/7 Entry order dated.
Lordship, interim order
Dated so and so.
Lordship 7/3/25.
7/3/2025 shall continue in the next date of hearing.
Obliged, Lordship.
Yes. Yes, anything you want to say? Apparent.
Page 11, 41 to 43.
Proceeding कर देंगे सगळं. सेपरेट अच्छे तो हम टेबल पर अलग रखे जोटा एक आसला करेक्शन ही नहीं से सर कौन कहते मेंशन आपण का मेंशन करते
item 18.
18 टा ये जो it's not maintainable in the single contempt because writ petition has been dismissed and in writ appeal they have got a order. And so before single judge this contempt is not maintained.
से आसु आगो दिन डेट कर दियो आपण जो दिन कहिबे कोर्ट मास्टर कर देबे जो दिन कहचनी कर अन्य मात्र कोन कोन स्पेसिफिक डेट करिवे ना केमती कोन करिवे डेट करबे नहीं आरो वीक ना आरो वीक माने आपण वेकेशन पोस्ट वेकेशन जोटा कहछ पोस्ट वेकेशन आपण जो काली रहले नी आपण मते कहितले 14 रे पोस्टिंग न करिया पे मोर मने पड़ला नै मु गुडे कर देबे तब जहाँ करेंगे डिवीजन बेंच मध्ये अच्छे 15 डिवीजन बेंच अच्छे 16 कोर्ट हमारे थैंक यू